Mic check 1 2. Hello. Welcome. This is Just Human, episode 355. We have updates in United States v. Comey. Of course, that is the case that keeps on delivering filings at a relentless pace, it seems. John Bolton's case, I haven't forgotten about it. There just hasn't been much happening with it. But we're going to talk about the latest filings in the Comey case. There was a pivotal hearing, actually two hearings last week, and then we have a new order from the magistrate judge who's handling the filter team matter and disclosure of the grand jury materials. And he's once again ordered that those grand jury materials, all of them, the transcript, the recording, all documents related to it, should be produced to Comey's team so that they can look at it and see if there was any misconduct or violations of his rights that could form the basis of a motion to dismiss. He has found that there are. There are 11 findings in his order, and then plus his conclusion, and the order that he actually made has like 4 or 5 components to it. So I already covered that in another short video. Well, short for me, about 35 minutes or so. And then we're also going to talk about a new and superseding indictment in a United States v. Arnold, which is an Antifa related case out of North Texas. There was that ICE facility in the Prairieland ICE facility that was attacked on July 4th by a group of Antifa. And they had firearms and they fired at federal officers and a responding Alvarado police officer who was hit in the neck. He did survive, but there are murder charges, terrorism charges, riot charges, and others. And it's a very significant case. It's the first time that terrorism or terror-related charges have been brought against members of an Antifa group. And I think I think this is the first of many cases where we're going to see this happen. So I promised I would track that case, and I promised when the superseding indictment came down that I would cover it. And I've done that. Now I'm going to, on this episode, on those two topics, I'm going to do something I haven't done before, and it's mostly for my Substack followers I consider them to be the core of my support over at justhuman.substack.com. Because I just put the podcast over there, they're not getting the shorter videos that I'm doing on Rumble and on YouTube. And so what I'm trying to do is convert to doing a brief explanation, a shorter version of it, and then going into the documents afterwards. So in this podcast, I'm going to include these 2 shorter videos, and then immediately at the end of the conclusion of those short videos, I'm going to get into the documents. So after the one covering the happenings in the Comey case, we're going to then read the judge's order, Halligan's emergency motion for a stay, Comey's response to that. And then in the Antifa case, we're going to, it's immediately following this 20-minute intro into it, we're going to read the superseding indictment. And I would like your feedback on it to let me know from you on Substack if you like me doing it this way. Because I know that some of you only go to Substack, either because you don't like the ads on Rumble or the ads on YouTube, or for whatever your reasons are, whatever it is. But I don't want you to miss out on some of the content that I'm creating over there. And since I'm putting timestamps in the podcast, which are right down here, and I'm adding a description so you can skip around. If you've already seen one of the shorter videos, you can just skip past that using the timestamps. And Substack doesn't have clickable timestamps where you can jump around, but I'm still including, I'm still typing out the timestamps and when in the show I'm covering different topics. So if you've already seen one of those videos, you'll be able to just skip ahead. So particularly from the Substack crew, I would like some feedback on this iteration of the podcast. So, all right, welcome. My link tree, as always, is in the description of the show, wherever you're watching or listening. And it's also in my profile, wherever you're following or watching or listening. And there you can find all the places to follow me, all the places to watch, all the places to listen, and all the different ways to support. There's Benson Honey Farms. Mo Benson has had some health problems over the past year, some very serious health problems. And I just heard from her for the first time in months. And she's doing much, much better. So if you're so inclined, head over to Benson Honey Farms, whether you use my affiliate link or not, and make a purchase and maybe send her family a note telling her that you're thankful that she's healed up and that she's survived. She's really been through it. There's also affiliate link for bootleg products, Manly cans. If you want to buy me a cup of coffee and keep me caffeinated, ko-fi.com. And then justhuman.substack.com is the core of my support. $7 a month. You're basically buying me 1 cup of coffee a month, and you're contributing a couple bucks to my Pacer fund, which, as these cases that we're following keep building and being active, and I keep picking up more cases to follow, I'm spending more money on Pacer. So thank you very much to everybody who's contributing to that. I just see that I'm about to hit 600 subscribers on YouTube. That's awesome. Sweet. If you're not following me on YouTube, please do. Welcome to everybody who's new over there. Comments make a huge difference on YouTube. So if you're so inclined, whether you're commenting to tell me that Comey is a dirty cop or reminding me to turn on my lava lamp, which I forgot to do in a video, one of these videos down here earlier this week, it helps. So, okay. Let's get into, we're going to do the Antifa topic first, this superseding indictment. And then we're going to go into the Comey update and the documents associated with that. Hey, folks, about a week ago, I covered the news that the U.S. Department of State had designated 4 Europe-based Antifa groups as foreign terrorist organizations. When a group is hit with that FTO designation, it opens up a whole host of new tools to the Department of State, Treasury, and the DOJ to use against that group and their supporters, including being able to freeze their bank accounts, tap their communications, track their support network, and go after people who either contribute to, in some, whether it's material support or financial support to that group, track their operations, and ultimately suppress or eliminate that group's ability to carry out violent acts of terrorism, whether in Europe or in the US. I made about a 15-minute video covering the moves that the U.S. has been making against Antifa, basically starting in September. Although there were some actions before then, President Trump made his declaration, which I'll speak about again here in just a minute. And I also got into this new designation against these 4 Europe-based groups and who they are. And then I talked a bit about a case out of North Texas that's called United States v. Arnold. This has to do with an Antifa cell in North Texas attacking an ICE detention facility on July 4th of this year. It's a unique case, and even though it's unique and it's a landmark case, it's not the first time that members of Antifa have been indicted for crimes, including crimes of violence, even attempted murder. But it is the first time that DOJ has brought terrorism-related charges against members of Antifa. And that's what makes this case landmark. In fact, I think if this case goes ahead and goes well, is a successful prosecution of these members and those charges stick, I think this case could serve as a template for future cases against members of Antifa. And I'd like to talk to you about a new development in this case, a couple new developments, including a superseding indictment. Welcome to my channel. Welcome to my videos. If you're new here, please consider subscribing or hitting the follow button, hit the bell, leave a like, and leave me a comment. Every time you leave a comment, especially on YouTube, it really helps my videos show up in people's algorithms, and just helps my videos get out there. In the description of this video and also on my profile, wherever you're watching or listening to this, you're going to find a link to my link tree. And there you can find all the places to follow me, all the places to watch, listen, and all the ways to support. Thank you to everybody who uses my affiliate links, keeps me caffeinated. And most of all, thank you to everybody who's a subscriber at justhuman.substack.com. Everything over there is free, but $7 a month subscription over there really helps me stay caffeinated and also pays my Pacer bills for the documents that I'm about to present to you. So thank you all very much. Let's get into the docket of United States v. Arnold. And to do that, I'm going to go with this thread, which, by the way, recently I have added a link on my link tree to my threads over the Thread Reader app. So if you're not on X but want to read my threads, you can find them there. All right. So federal prosecutors filed a superseding indictment last week in the criminal case against the North Texas Antifa cell. The case is remarkable because it is the first time an Antifa group has been hit with terrorism charges. On the night of July 4th, 2025, near Alvarado, Texas, the Prairie Land ICE detention facility, the vehicles at the facility, and the guardhouse, as well as federal agents working there, and also responding Alvarado police officers, were attacked by a group of almost a dozen people. The attack was part vandalism, but also part ambush. It was a coordinated assault with several groups of attackers. One group used fireworks to distract, disorient, and suppress law enforcement, while another group vandalized structures and vehicles. And yet another group ambushed law enforcement with firearms. The attackers had body armor, they had med kits, and some of them carried firearms. A responding Alvarado police officer was shot in the neck by one attacker who was positioned in a nearby tree line. He did survive, and I did read that that officer has returned to duty now. Another assailant, who was also armed, fired somewhere between 20 and 30 rounds at responding ICE facility officers. Some of the people who actually worked at that facility were coming out of the building to see what the noise of the firecrackers were and what the radio traffic was, and they were immediately fired upon. Here are some of the members of this group who were arrested. There's more than this, though. I got this graphic courtesy of Andy No, who has for years now done outstanding work tracking Antifa's operations. Initially, just days after the attack, 10 defendants were charged. Many of them had been arrested that same night on scene, but others got away. They were charged with attempted murder of a federal officer, 3 counts of that, and 3 counts of discharging a firearm in furtherance of a crime of violence. But this was just the initial complaint. Around September 22nd, 2025, things started to shift in this case. That's, I think, at least partially because Trump did a thing. While designating a group as a domestic terrorist organization like he did here in this executive order on September 22nd isn't really a thing. It's not a thing in U.S. law, domestic terrorist organization. It's kind of a media construct that's been made up. And that's probably why Trump chose to use this. That's not a thing. However, the president directing, quote, all relevant executive departments and agencies to utilize all applicable authorities to investigate, disrupt, and dismantle any and all illegal operations, especially those involving terrorist actions conducted by a group. That absolutely is a thing. And that was the real purpose of this executive order. While media ran around with their articles and their little clips on their night shows talking about how Trump can't do this, Antifa is an idea, domestic terrorist organization isn't real, the meat of this executive order was right here. Now, like I said, I've been aware of this case since that initial complaint. I've been tracking it. I've brought it up a couple times on my podcast, and then I made that 15-minute video about it last week. And one of the things I've noticed about this case is there's a lot of filings missing. Everywhere I have red box represents numerous filings that are absent from this docket. You can see it skips from 1 to 6, and then it skips from document 7 to document 31, and then it skips 31 to 39, misses 41 and 42 and 44 and 46, 47, 48, gets a few in a row right here, but then it skips 54 through 61, 61 through 77, 79, skips document 80 and 78, skips 83, and then it starts getting a little bit more regular. There's still some missing, but there's 107 docket entries here, and I think about half of them aren't actually on the electronic docket. It always stands out to me when things like that happen. I suspect this is due to the Pacer hack that the U.S. court system was alerted to in early August, and I've talked about that on my podcast and in other videos. Ever since that attack, courts have been keeping sealed or sensitive filings off of Pacer. Sometimes there's a placeholder entry that notices there and just says there's a document here, here's what it's about, but it's not filed. So that way it can't be hacked, at least not filed electronically. But more often than not, I think filings just aren't there. It's just, they just skip the docket entry. And yes, I'm a bit grumpy about this. Weeks after the president's executive order, a grand jury returned an indictment against two of the defendants in this case. Cameron Arnold, who's the namesake of the case, he's AKA Autumn Hill, and then Zachary Evans. They're the two leaders, it would appear, of this terrorist group, or Antifa cell, I should say. The charges that the indictment, remember, we already had a complaint back in July against them, but now it's been upgraded to an indictment thanks to a grand jury. And this is when they were hit with the providing material support to terrorists, making this case the first of its kind. They also were hit with 3 counts of attempted murder of a federal officer and 3 counts of discharging a firearm in relation to a crime of violence. Extremely serious charges. For the first time, members of Antifa cell had been hit with terrorism charges. AG Bondi posted, as POTUS has made clear, Antifa is a left-wing terrorist organization. They will be prosecuted as such. By mid-October, just a couple weeks later, the FBI had made over 20 arrests tied to this case and related Antifa networks. I haven't been able to find all those cases. There's not 20 defendants in this case. So there's other actions happening, and I'll spend some time looking for them and see if I can find all those cases that are connected to this. But I'm thinking that a lot of these unfiled filings that are absent from here may have something to do with these other arrests. I'm also thinking that if any of those arrests have information such as cooperating witnesses or evidence, we may find out about them through filings in United States v. Arnold. Episode 348 of my podcast is where I initially touched on this landmark Antifa case. Last week, as I said, State Department designated those 4 European groups as FTOs, foreign terrorist organizations. What we didn't know at that time was that on the very same day, a superseding indictment was returned in this case. That's no coincidence. It cannot be a coincidence that the State Department did this on November 13th, and that is the very same day that DOJ files a superseding indictment in this case, right there. Boom. Love it. Now, we can't infer from that those 4 European-based groups are linked in some way to this case, but I think it shows coordination between the president, AG Bondi, Kash Patel, the Treasury Department by extension, because they're going to be involved in this, and then Marco Rubio at State Department. It shows that they're coordinating to all go after these Antifa cells. Now, one of the updates that has been happening in this case, things I've been tracking in it since my last video, was that the government filed in here that the government sent plea offers to all of the defendants. All the defendants who appeared on September 23rd, which was more than 10. I believe it was 15 defendants in total ended up being charged in this case. Yeah, 15. The government told the judge that we anticipate a fair number of those offers are going to be accepted. And for the defendants whom the government cannot reach agreement on a plea offer, the government intends to supersede the current indictment, adding those defendants into the Arnold/Evans indictment, as well as additional charges. This filing right here was part of a notice to the court that they would like to designate this case as complex. When a case is designated as complex, it basically waives the Speedy Trial Act and says there's so much discovery here, there's so much complication with this case that it's not feasible for either the prosecution or the defense to get the case to trial before the deadlines that are part of the Speedy Trial Act. So they're asking the judge to designate a complex so it waives that speedy trial right. And it serves both sides. So by noticing the court that they were doing this, or in noticing the court of this, they also let the court know that they had so far put together 5 terabytes of discovery. However, there's much more on the way. They next filed a motion, and it may have been on the same day. It doesn't really matter. It may be. It was really close to that noticing of complex, that they told the court that there's going to be classified information at issue here. So they're going to have to bring in the Classified Information Procedures Act, which is another complication, is in a reason to designate it complex. But it's highly interesting to me that this North Texas Antifa cell, this group, I already showed you their pictures right here. This motley crew, the US DOJ has classified intel on them, or classified intel that is related to their case, and it's information that they want to bring against them and use at trial. That's interesting. So they told the court of that, and then I feel like there was one other thing I was going to tell you guys about this. I don't see it. All right, anyway. So that superseding indictment came out same day as the 4 European groups were designated, and now there are 9 defendants in the case. So that means 6 probably accepted a plea agreement with the government. And that means 6 former defendants in this case may end up being cooperating witnesses against these 9. Here's how the new indictment defines Antifa, and I think this is one of the reasons why this case can serve as a template, because now DOJ is defining what Antifa is in a criminal case against Antifa members. The Antifa cell. Antifa is a militant enterprise made up of networks of individuals and small groups primarily ascribing to a revolutionary anarchist or autonomous Marxist ideology, which explicitly calls for the overthrow of the United States government, law enforcement authorities, and the system of law. Antifa adherents have espoused insurrection and advocated violence to affect the policy and conduct of the U.S. government by intimidation and coercion. I think those words right there are what all of us can now use against any media talking heads, against any leftists, if you feel like engaging with them when they tell you that Antifa is just an idea. Sorry. This is how the U.S. government defines Antifa. And you can also respond to people who say that by saying, well, the mafia is just an idea. After all, mafia just means family in Italian. Mafia. It just means family. But the DOJ, through prosecutions of members of La Cosa Nostra and others, put together a functioning definition and meaning to the word mafia. And we now all know what the mafia is and what it means when someone says that they're talking about a criminal organization. And this Antifa designation is no different. We're talking about a criminal organization. And it's been defined now in a court filing, in an indictment. Now, the charges that were added here really leveled this case up. Count 1 is now riot. Count 2 is providing material support to terrorists. Count 3 and 4, conspiracy to use and carry an explosive. Counts 5, 6, and 7, attempted murder of federal officers. Counts 8, 9, and 10, discharge of firearm and violent crime. Counts 11, count 11, corruptly concealing document or record. And count 12, conspiracy to conceal. I think those last two stem from some of the defendants in this case were trying to help those who weren't apprehended on scene on July 4th, trying to help them escape. But Texas was able to apprehend them. So those who are hit with the riot charge are Arnold and Evans, and then Benjamin Song, I believe, is the leader of the group. I've seen that written that he is the leader. And then Batten, Morris, Rueda, Soto, both Sotos, I think they're brother and sister, Elizabeth Soto and Inez Soto. So that's 1, 2, 3, 4, 5, 6, 7, 8. 8 defendants are hit with a riot charge. 1, 2, 3, 4, 5, 6, 7, 8 defendants hit with material support to terrorist. 8 hit with count 3, conspiracy to use and carry explosive. 8 of them are hit with count 4, which is use and carry of an explosive. Count 5, attempted murder. That's going to be 1, 2, 3, 4, 5 of the defendants have been hit with count 5. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. Yeah, so the attempted murder charges are against 5. There's 3 counts of attempted murder. Because there's a count for the Alvarado Police Department official, a count for the correctional officer, and a count for attempted murder on another federal officer. And then 5 of them, then those same ones are hit with 3 counts of discharging a firearm and commission of a violent crime. And then the concealing charge is where we get the other defendants brought in, Rolanado and Estrada. So, huge development in this case. I'm going to keep tracking it and covering this on these short videos, and then also on my main podcast, which now that I've done this short video, I'm going to, for my podcast listeners, I'm going to go into the indictment itself, and we're going to read through it and see exactly what DOJ has, at least according to the superseding indictment, what they have against these 9 defendants. So if you're on the podcast, let's dive into it. If you're not watching the podcast, check it out. This will be part of episode 355. All right. All right, podcast listeners, we're going into this indictment. We do have a couple nicknames here. Autumn Hill for Cameron Arnold and Megan Morris for Bradford Morris. So I think we can go ahead and deduce from that he's trans. And that's pretty easy to believe looking at this photo lineup. This is more than the defendants that are actually in this case. And in total, there's over 20 people who have been arrested in connection with this and other Antifa cells. Okay, so the superseding indictment starts off late at night on July 4th, 2025, a North Texas Antifa cell of at least 11 operatives rioted and attacked the Prairieland Detention Center in Alvarado, Texas, which the U.S. Department of Homeland Security was using to house illegal aliens awaiting deportation. Members of the cell wore black bloc, dark clothing with head and face covering that concealed their identities. This tactic is designed not only to hide each individual member's identity, but also to aid and abet those members engaged in illegal acts by making individual members indistinguishable from one another to law enforcement. Some members also brought body armor and firearms to the Prairieland facility. After arriving, the Antifa cell began shooting and throwing fireworks, which are the explosives that are charged in this thing, towards Prairieland and vandalizing vehicles and a guard shed on Prairieland property. So there's the guardhouse that was vandalized, and I am not sure what object they're trying to show us there on the ground. I wonder if that's a mirror or something on the vehicle that's been broken off. It does look like it has a flat tire. This might be a mirror or like a spotlight on this vehicle that was broken off, something like that. Alarmed at the presence of unauthorized persons on Prairieland property late at night, unarmed DHS correctional officers inside the facility went outside to investigate. Other DHS personnel called local police for assistance. Within minutes, an officer from the Alvarado Police Department arrived on scene, stepped out of his police cruiser, and began issuing commands to Nathan Bowman, a co-conspirator not named as a defendant herein. Ooh, I bet he took a plea agreement, and it's gonna cooperate. Who was one of the rioters? He was one of the rioters vandalizing government property. Bowman, who was dressed in black bloc, continued to run towards Benjamin Song, who was dressed in black bloc and holding a rifle. Song yelled, "Get to the rifles," and then, moments later, opened fire on the officers, striking the Alvarado police officer in the neck area as the unarmed DHS correctional officers ducked and ran for cover. Ooh, okay. I hope they have this. I mean, I've seen it reported that Benjamin Song had yelled, "Get the rifles." I hope this is on body-worn camera and you can hear it, or at least on surveillance video. That will be really helpful in trial. The wounded officer fell to the ground, but was able to return a few shots. Song fired additional rounds at the wounded officer and the DHS correctional officers until his rifle jammed. The Antifa cell then fled the scene. Okay, that's also a crucial piece of info, because they can say, hey, he fired until he could no longer fire anymore. And it just goes to his state of mind that he was trying to kill these officers, which is already apparent by the shots, but the fact that he fired until his rifle jammed meant that he, it's not like 1-2 run away. It's just a little bit more there. Police arrested most of the Antifa cell shortly after the attack, many near the scene, including Zachary Evans, Bradford Morris, Elizabeth Soto, Inez Soto, Savannah Batten, Marciela Rueda, and Seth Sykes, Bowman, and Joey Gibson, co-conspirators not named as defendants. More people cooperating. Police arrested Cameron Arnold the following day. Benjamin Song escaped and remained at large with the help of others until his capture on July 15th. The Antifa cell. As I made a point, I think this is one of the most important pieces in this indictment. Antifa is a militant enterprise made up of networks of individuals and small groups, primarily ascribing to a revolutionary, anarchist, or autonomous Marxist ideology, which explicitly calls for the overthrow of the United States government, law enforcement authorities, and the system of law. Antifa adherents have espoused insurrection and advocated violence to affect the policy and conduct of the U.S. government by intimidation and coercion. Beginning in 2025, Antifa adherents have increasingly targeted agents and facilities related to the DHS Immigration and Customs Enforcement, ICE. They're in opposition to ICE's deportation actions and the U.S. government's policy on the removal of illegal aliens. The Antifa campaign involves coordinated efforts to obstruct enforcement of federal law through organized riots, violent assaults, and armed confrontations with ICE and law enforcement officers. Most of the Antifa cell looked to Song as a leader. Song and others recruited for the Antifa cell from various ideologically aligned groups. For example, Inez Soto, Elizabeth Soto, and Batten were part of a group that created and distributed insurrectionary materials called zines, or zines. I bet it's zines. Song also recruited at gun ranges and close quarters combat training sessions he conducted. Okay, so these insurrectionary materials, those are going to be really helpful in getting a conviction and proving the ideology of the group. And then Song conducting close quarters combat training. If they have video or materials from that, that could be really helpful too, because again, it would go to state of mind, the purpose of what they were doing, all of that. Altogether, members of the Antifa cell acquired over 50 firearms in Fort Worth, Grand Prairie, Dallas, and elsewhere. Wow. Song, for example, bought and built numerous AR platform rifles, some of which he distributed to his co-defendants, and at least one of which featured a binary trigger. Oh, I just realized my lava lamp's not on. Oops. A binary trigger is a device that allows a firearm to fire more rapidly by causing 2 bullets to fire with each trigger cycle. To hide their involvement in illegal conduct, the Antifa cell emphasized and practiced operational security, or OPSEC, in their communications. For example, members used an encrypted messaging app to coordinate with each other. This app allowed for group chats and had auto-delete and delete after a timed functions, which caused communications among the Antifa cell to be permanently deleted. Most Antifa cell members used monikers in the group chats to hide their true identities. Group chats dedicated to planning direct actions were limited to trusted participants, and even among trusted participants were exclusive to those with a need to know. All right, the defendants. Song was a resident of Dallas and used the monikers Champagne and Delete. Arnold, aka Autumn Hill, was a resident of Dallas and used the moniker Not Beating the Little Creature allegations. Batten was a resident of Fort Worth. Bowman was a resident of College Station and used the moniker Bible. Evans was a resident of Waxahachie and used the moniker John Valjean. Gibson was a resident of Dallas and used the monikers Foxglove and Rowan. Morris, aka Megan Morris, was a resident of Dallas and used the moniker Herald of the Mad God. Rueda was a resident of Fort Worth and used the moniker Malcriada. Elizabeth Soto was a resident of Fort Worth. Inez Soto was a resident of Fort Worth and used the moniker In. Daniel Sanchez Estrada was a resident of Fort Worth. Seth Sykes was a resident of Kennedale and used the moniker Wise. The plan. In the days prior to July 4th, the Antifa cell planned and coordinated the riot and attack against Prairieland using several group chats on an encrypted messaging app. One chat, which was named the 4th of July Party, consisted of the core group that planned the action, and that's going to be called the core chat. The core chat originally had 8 participants, but 2 dropped out for OPSEC reasons after they stated they would not attend the July 4th action. The 6 remaining members were Evett, Song, Morris, Gibson, Rueda, and Sykes. Members in the core chat conducted detailed reconnaissance and planning. For example, Evans and Rueda attended a peaceful protest at Prairieland earlier in the day on July 4th in order to scout the facility. Evans relayed in the core chat details about the fences and gates, including the time it took for the gates to open and close and how long it took trash pickup to get in and out of the facility. Rueda circulated a picture of a security camera at the entrance to the facility and noted that a nearby house had a doorbell camera. Evans assessed that signs, laws, and social pressure are the only things keeping someone from getting right up to the fence. Rueda posted a Google map that showed the location of a local police department in relation to Prairieland. The members of the core chat planned what materials to bring to the riot and the attack, including firearms, medical kits, and fireworks. For example, Evans asked the core chat group if they would be, quote, doing black bloc and rifles. Gibson stated that they would be wearing block and keeping kit on hand. Quote, bringing a wagon to hold armor and rifles. Okay. When Rueda suggested that rifles might make the situation more hot, Song replied that rifles would be used to intimidate law enforcement, stating cops are not trained or equipped for more than one rifle, so it tends to make them back off. That's good evidence to have. Now, the defense might take that and say, hey, look, they're not trying to kill. They might try and use that statement to defeat the attempted murder charge and say it was an accident, that an officer was actually hit. They weren't actually trying to shoot any officers. They wanted to use the rifles to make them back off. But that'll be for trial. But there's that line right there. No, it both is inculpatory and exculpatory potentially. Of that one, I'm not saying they won't get convicted on a lesser charge, but defense will try and get get the attempted murder charge knocked down based off a statement like that. Song also advertised the July 4th riot on a larger chat, which was called the Large Chat, but left out certain details in an effort to avoid being identified as one of the organizers. As Rueda warned in the core chat, if anyone pins us for organizing, that's where we'd lose. Mhm. The large chat included, that's an admission right there. The large chat included Song, Arnold, Bowman, Evans, Gibson, Morris, Rueda, Inez Soto, and dozens of trusted individuals. Song circulated a flyer for the Prairieland riot in the large chat, stating, quote, "Share with trusted folks only, do not post, mask up, be loud." Members of the large chat discussed the event as a noise demonstration involving fireworks. Participants in the large chat expressed concerns about law enforcement's response to the action. For example, Bowman noted that the area around Prairieland was, quote, "pretty rural, so it will be difficult to lose ICE if shit hits the fan. Plus, seems like a lot of the locals in the area will not be happy about our presence." And as Soto responded that they were probably, quote, "more likely to deal with local PD than ICE," but suggested that, quote, "the level of concern seems way over the top to me." Throughout the large chat, Inez Soto and Rueda attempted to downplay concerns about law enforcement, urging action and referring to noise demonstrations as low risk. In addition to the encrypted messaging group chats, Song, Arnold, Morris, and others met in person on July 3rd at a gear check at Morris and Arnold's residence. There, Arnold asked Song if they would be bringing guns to the July 4th action. Song replied that they would because he would not be going to jail. Song repeated words to this effect multiple times throughout the evening, putting everyone there on notice of his intent to shoot at police rather than be arrested. Okay. This is testimony from a witness. I mean, unless they recorded their gear check, this sounds like testimony they have from a cooperating witness. There are the encrypted group chats up here, but it says that those were instructions to, it says in addition to encrypted messaging group chats, Song, Arnold, Morris, and others met at the gear check. So the and others, among that group of and others, they're getting this testimony about the things Song said. Song, Arnold, Evans, Gibson, Morris, and Rueda staged at Morris and Arnold's house on the evening of July 4th and carpooled to Prairieland. Elizabeth Soto, Inez Soto, and Batten drove together and arrived at Prairieland a little later than Song and the others. So there's 2 vehicles. Bowman drove by himself, now 3 vehicles. He drove by himself from College Station. The Antifa cell brought a total of 11 firearms, 4 of which had been purchased by Song. So that's enough for everybody. Okay, and then it says paragraphs 1 through 26 are incorporated in each count of this indictment. And then we get to the count, which I've already gone through with you. So the superseding indictment is just going to tell us count 1, riot. They aided and abetted each other, used at a facility to intersect commerce, cell phones, and automobiles in order to organize, participate in, and carry out a riot. This included shooting and throwing fireworks and explosives at the Prairieland Detention Center and its perimeter fence, slashing tires on a government vehicle, spray painting graffiti on government and private property and vehicles, destroying a closed circuit camera, shooting at a police officer and unarmed DHS correctional officers, dressing in black bloc in order to prevent law enforcement from identifying individuals engaging in the acts described above. Count 2, providing material support to terrorists. This is, it's just everything. It's the resources, it's the communication, it's the transportation, it's the weapons, the fireworks, the armor, the med kit. It's just all the things that's the material support, actual things that were provided. And then the concealment, the black bloc concealment, it was all used in preparation for the riot and the attack. And then there's conspiracy to carry and use explosives, which is the fireworks they used. 2 counts of that. Well, conspiracy to do it because they talked about it beforehand, and then the use and carrying of it because they actually used the explosives and they did carry it to the facility. Count 5, attempted murder. So this is on Correctional Officer 1. He's a federal officer at the Prairieland facility. And then another attempted murder charge against Correctional Officer 2. And then another attempted murder charge against the Alvarado Police Department officer who was actually hit. And then 3 counts of discharging a firearm. So that's going to be in relation to those murder charges. Count 11, corruptly concealing a document or record. And then this was after the attack between July 5th and 6th. This is Daniel Rolando Sanchez Estrada concealed a record, document, or other object, or attempted to do so, to impair the ability of law enforcement to conduct a official proceeding. He transported a box that contained numerous Antifa materials, such as insurrection planning, anti-law enforcement, anti-government, anti-immigration enforcement documents, and propaganda, from his residence in Garland, Texas, to a location in Denton, intending to conceal the documents or the contents of the box. So they have all that stuff. That is excellent. Okay, count 12, conspiracy to conceal, same thing. The purpose of the conspiracy was for Sanchez and Rueda to conceal documents and other objects that would implicate Rueda in the riot and the shooting at the center on July 4th. Sanchez, Rueda, and others, known and unknown, sought to accomplish the purpose of the conspiracy by having Sanchez conceal incriminating evidence, including the planning material and propaganda and all those other things. Sanchez moved his evidence from his residence. Sanchez did so intending to conceal the contents. And further to the conspiracy on July 6th. Okay, yeah. And then signed, by the way, this is another acting United States attorney, Nancy Larson, is the acting United States attorney for the North District of Texas. Will be interesting if her appointment is challenged in this, like we've seen in other cases we've followed. Boom. Boom. I'm excited to track this case and see how this goes for DOJ. I hope it goes very, very well. And I'm going to search for any of the other cases I can find that may also bring terrorism-related charges to Antifa. More good stuff happening, right? Excellent. Most excellent. Surprised this isn't bigger news, to be honest. But there's a lot going on, and people get distracted by football, Epstein, stupid influencers engaging in rage baiting. All right, let's go to the next topic. Hey, folks, yesterday, November 17th, was a pivotal day in the case of United States v. James Comey. On a motion to disclose grand jury material, something that's been argued for a couple weeks now or so, Comey prevailed, and prevailed in a very big way. The judge had lots to say after he reviewed the grand jury materials and proceedings. The judge arrived at a conclusion and made about 10 or so findings as to misconduct, misstatements of law, and violations of Comey's Sixth Amendment and Fifth Amendment rights, and possibly Fourth Amendment rights as well. It's ugly. It appears to be a very, very ugly situation for the DOJ and for U.S. Attorney Lindsay Halligan. And the judge ordered those grand jury materials, all of them, to be disclosed to Comey's team by 3 p.m. yesterday. But at 3 p.m., did that happen? No. Instead, U.S. Attorney Lindsay Halligan filed an emergency motion to stay the order, meaning pause it, don't enforce it. We want this reviewed by another judge. We think that Magistrate Judge Fitzpatrick erred in his ruling to disclose these materials to Comey. Her motion for an emergency stay wasn't all that compelling, I have to say. It was pretty weak. However, the motion in opposition that James Comey's team have filed, maybe they filed it about an hour or so later. It was very strong. but it offered a compromise which District Judge Nachmanoff took up. So the order is stayed for now. Comey doesn't yet have the grand jury materials, but he does have a big victory, and the momentum in this case, the story of this case, is very much in Comey's favor. And I think characterizing the case differently to that, I don't think it's a fair reading of the case. Now, if you've been following the case with me, reading my threads, watching my podcast, and the shorter form videos that I've been doing on Rumble and YouTube, then you weren't surprised by yesterday's development. We've been expecting it. We've been discussing the grand jury materials. We've been discussing the irregularities that were alleged about the grand jury. We've been discussing the privilege leaks and all sorts of pretty much every other issue going on in this case. And that's because we've been tracking the case since the day it was filed, document by document, filing by filing. We've been reading them together and extracting the tidbits of new information and analyzing the arguments in the filings and forecasting what was ahead. And what happened yesterday was something that we talked about was a very likely decision, if not inevitable, right? Thank you to everybody who has been tracking the case with me. If you would like to join us in tracking this case, we're having a good time. Because we pay attention to the day-to-day filings of the case, we tend not to overreact to anything that happens in it, because we're just tracking the story of it instead of peripherally picking up new crumbs of information about it from influencers and clickbait media. And it's a much more enjoyable way to follow a highly interesting criminal case that could have big impacts on other criminal cases that are currently going on and that have yet to be filed. If you go to the description of this video or in my profile, wherever you're watching or listening to this, you'll find my link tree. And on my link tree, you can find all the places to follow, watch, listen, and all the ways to support the show. Thank you to everybody who clicks my support links and contributes to my coffee fund and my Pacer fund. Really appreciate you guys. Now, in my most recent episode of my podcast, which is episode 354, it's available on justhuman.substack.com. Everything on my Substack is free. It's also available on YouTube, on Rumble, and on YouTube and Rumble, we have playlists for United States v. Comey, and it's available on my x.com account. I put all of my episodes in the highlights section. So if you just go to my profile and click on highlights, you'll see all of my recent podcast episodes there. And if you click the show more button, you'll see the timestamps for when we discuss different aspects of the Comey case. Now, I do think my most recent episode is one of the best I've ever done, or at least in recent memory, it's one of the best. I covered 3 main topics in it. 1, the most recent updates in the Comey case. 2, newly disclosed emails from 2017 that show an FBI agent in the Washington field office trying to get an investigation into Hillary Clinton paying for the Steele dossier, trying to get that investigation started and being shut down by DOJ's Public Integrity Unit and the U.S. Attorney's Office of D.C. And then finally, in the last hour of that show, I do a 4-year consideration, new perspective on the origin of Russiagate and maybe what Russiagate, Crossfire Hurricane, and everything going on with the Steele dossier was really about. And I don't think what it's really about is how media on the left or the right have long characterized it. But as pertains to the Comey case, and specifically what we're about to talk about in this video, if you go to about 55 minutes into that episode, I discuss the most recent filings in the Comey case, including new affidavits from U.S. Attorney Halligan and AG Bondi, her new order, and then new affidavits from the 2 FBI agents who were involved in this case. Actually, that part is at 29 minutes in, and then new filings clarifying grand jury proceedings are at 55 minutes in. So it's all within that first hour that I address this stuff. But if you missed that, don't worry, I'm going to brief you back up on it. I'm going to need a sip of my coffee. This video is probably going to go a bit longer than I would like it to because there's so much to talk about here. But like I said, yesterday was a super important day in this case, and it started off with a huge win for Comey. Magistrate Judge Fitzpatrick, once again, he's already made this determination and already issued this order before, finds that disclosure of grand jury materials is warranted in the case. He orders DOJ to turn over all grand jury materials to the defense by 3 p.m. today and all audio recordings by 5 p.m. What got us to this point is a bit complicated, but I have covered it in several threads and videos over the past few weeks. So I'm not surprised by this order, and I'm sure my followers who have watched those videos and read those threads aren't surprised at all either. If you want to avoid reactionary takes and understand what is going on in United States v. Comey, I'm your guy. All right, here's what you need to know as background to what happened yesterday, and about as quickly as I can tell it to you. There's 3 judges involved in United States v. Comey. There's the Eastern District Judge, Judge Nachmanov, and he's handling the criminal proceedings, the criminal case. He's handling all the filings that have to do with the pretrial leading up to discovery, leading up to the trial, and then he's going to handle the trial himself. But there's 2 other judges. Magistrate Judge Fitzpatrick was brought in to handle the issue of a filter team. On October 13th, all Rule 16 discovery, which is discovery of evidence that the government has against you, had to be turned over in this case. That was Nachmanov's order. On October 13th, DOJ had turned over about 85,000 pages of discovery to Comey's team. However, they had left out a small number or a small amount of discovery that was created during the Arctic Haze investigation. The Arctic Haze investigation happened 5 years ago or so. It was a media leak investigation, and Comey and Richmond were investigated, among others, for leaking classified information to the New York Times for an article, or information that wound up in an article. Magistrate Judge Fitzpatrick is handling that issue because it has to do with privileged communications. The reason that DOJ didn't turn over that evidence to Comey is because they realized there had been, and this is what it seems like based on filings in the case, there had been a screw up. Communications between Comey and Richmond, while Richmond, who is person 3 in the indictment, was retained by Comey as a personal attorney, were seized pursuant to 4 search warrants issued during Arctic Haze. It seems like this shouldn't have happened. And these privileged communications, which are covered by attorney-client privilege, were never filtered out of the rest of the evidence. And it looks very much like DOJ arrived at the moment on October 13th to turn over all of this discovery they had against Comey and realized they were in possession of attorney-client privilege communications that they should have dealt with before bringing the case. And so what they do on October 13th is they file a motion for a filter team. A filter team would consist of investigators and attorneys from outside of the investigative unit and the U.S. attorneys who are handling this case. And they would independently review that evidence, separate what may be attorney-client privileged from the stuff that isn't. The stuff that isn't could be turned over if the government intended to use it against Comey at trial. The stuff that is attorney-client privilege, the DOJ could then go to the judge and say, hey, we think that these communications, even though they're between an attorney and his client, we think there's a reason that it can be disclosed, such as the crime fraud exception. There are exceptions to attorney-client privilege. But they would have to go through that process in order to get a judge to sign off on DOJ being able to use those attorney-client privilege communications against the defendant. That is what the process that DOJ tried to start on the very day that this type of discovery was already due. To handle a matter like that, it's necessary often for the judge to bring in a third-party judge or someone outside the case for reasons of fairness and ethics, right? So he delegated that issue to Magistrate Judge Fitzpatrick. Magistrate Judge Fitzpatrick was told, or was delegated the authority to handle all proceedings related to the implementation of a filter team. 7 days after making that filing, asking for the filter day, well, actually it was a little less than 7 days, DOJ Halligan filed an expedite motion asking the judge to hurry up and grant this order. And the judge's like, I can't grant this order for a filter team. I haven't heard from the defense yet. And they have 14 days per the rules. Defense comes in and says, we're not necessarily opposed to the filter team, but we would like to challenge the underlying search warrants first because we believe that these communications should not have been seized in the first place. We think that there was a Fourth Amendment violation. So that makes things a little bit more complicated. So Fitzpatrick has been looking at this issue, and his first pass at looking at this issue was to say, yeah, it looks like there's some irregularities here and there should be disclosure. DOJ appealed that, said, no, we don't want to disclose this to Comey, and we don't think there's a basis to do so. There's a high bar for him to be able to break the secrecy of the grand jury proceedings, and he's not there yet. It goes back to Judge Nachmanoff. Judge Nachmanoff says, this is within Fitzpatrick's authority, and I'm remanding it back to him for further proceedings on the issue. We'll pick up with Fitzpatrick and what happened yesterday in just a moment, but there's another judge, a third judge that is involved in this case, Judge Curry. Judge Curry is the senior district judge from South Carolina. Now, the case is happening in the Eastern District of Virginia. However, Lindsay Halligan's appointment has been challenged. Both Comey, who Halligan indicted, and Letitia James, who Halligan also indicted, have filed motions to dismiss their indictments based on the unlawful appointment of Lindsay Halligan. I've covered that issue extensively, the filings having to do with that. I started off kind of thinking Halligan might not be lawfully appointed. That was where I was leaning. But DOJ's motion that she was very much compelled me that Halligan is lawfully appointed. Doesn't mean I think she's going to win on that issue. I'm not sure. But DOJ's filing on it was highly compelling and changed my mind. Senior District Judge Curry, it's has been brought in because it's a rule that if the appointment of a U.S. attorney has been challenged by a defendant, an out-of-district judge has to hear that challenge. So Judge Curry is handling all the stuff that has to do with Halligan's appointment. In the process of doing that, and this is where we find out why it's important to bring her up, Judge Curry is reviewing Halligan's handling of the grand jury. And one of the reasons she's doing that is because Halligan was the only prosecutor to sign off on the indictment. And if Judge Curry rules that Lindsay Halligan is unlawfully appointed, then she didn't have the power to indict, which means the cases are thrown out. In other states where U.S. attorneys have been challenged and their appointments have been ruled unlawful for whatever reason, the indictments that they brought stood because other prosecutors had signed off on the indictment as well. Not so in the Eastern District of Virginia. So Judge Curry is also examining the same grand jury materials and proceedings that Judge Fitzpatrick is. They're both looking at some of the same things. And that means that DOJ is contending with or making filings to both judges about the grand jury materials, which are the materials that Comey's team is trying to get disclosed. Okay. It's important to understand that at this time, there are two distinct threats to this case. And both of those threats are being handled by Judge Fitzpatrick and Judge Curry. One threat is the irregularities with the grand jury process, specifically the grand jury potentially being exposed to attorney-client privileged information. Two, Halligan being the only prosecutor to present to the grand jury. If there was a spill of privilege, if information to the grand jury that they shouldn't have had because it was attorney-client privilege was conveyed to the grand jury anyway, that would be solid grounds for a dismissal of the case because it's a violation of Comey's rights. If Halligan is found to be unlawfully appointed, like other interim U.S. attorneys have been recently, that could be grounds for dismissal because she's the only person who signed the indictment. Now, DOJ was already ordered to turn over these grand jury materials back on November 5th. And I covered that in this thread back on November 6th, and I have a video about that specific issue. DOJ appealed, arguing the magistrate judge did not have the authority to issue the order. It got remanded by Judge Nachmanov, and they made more filings. On November 10th, there were several filings leading up to the hearing that happened on that day. And that was when Fitzpatrick and Curry, they were both reviewing these grand jury proceedings. Today, Judge Fitzpatrick made his ruling, and he ordered that all the grand jury materials must be turned over to Comey. Now, what he found in his order is, like I said, ugly. The court finds the record in this case requires full disclosure of the grand jury material, and in so finding, the court recognizes this is an extraordinary remedy. But given the factually based challenges the defense has raised to the government's conduct and the prospect that government misconduct may have tainted the grand jury proceedings, disclosure of grand jury materials under these unique circumstances is necessary to fully protect the rights of the accused. In the filing actually, what I'm going to do is give you some of the highlights of what they found, okay? Or what Judge Fitzpatrick found was in the grand jury proceedings. He found that the 4 search warrants that were used against Richmond didn't cover the type of information that now the government is seeking to use to indict Comey. The 4 search warrants were before 2 other types of crimes, and they were limited in scope. And yet it appears that DOJ seized information that was outside the scope of those search warrants and now is seeking to use that information against Comey. That's why Comey says we want to challenge the underlying search warrants. The government never has engaged Comey in the process to review this stuff for the filtering the information, even though they know that Comey retained Richmond as an attorney on May 9th of 2017, the day he was fired. And they know that because they were informed of it by Richmond in writing. And yet they had 5 years to go through this material. They had 5 years to use a filter team. They had 5 years to bring Comey in to assert his privilege and then go through this process, and they hadn't done it. Arctic's investigators collected information from Richmond's iCloud account that was well outside the scope of the warrant and was well past the date on which Richmond was retained as Mr. Comey's attorney. There's possible Fourth Amendment violations here because the search warrants were for evidence of specific crimes. Those crimes were theft and conversion of stolen government property and unlawful gathering or transmission of national defense information. That's not what Comey's charged with here. Comey's charged with false statements and obstruction. When the judge asked the prosecutors about this, they simply did not know. They simply did not know. And to be fair to them, that's not surprising because the prosecutors who are on this case didn't investigate Arctic's. They weren't part of that team. And they didn't really investigate Comey at all in the lead up to the indictment. Lindsay Halligan added the 2 prosecutors on this case after Comey was already indicted. She brought them in from North Carolina and then handed them this thing. It looks like she saddled them with a very problematic case. This failure by the government is even more concerning because one warrant specifically directed the law enforcement officers to review and identify information in it that was responsive and to seal any information that was not, did not fall in the scope of the warrant. It gets worse. Inexplicably, the government did not elect to create a new search warrant in 2025 when they were investigating Comey. They could have done that. They did not. Instead, they used other information, open source reporting, open source information, the Comey's testimony, and then they went back to this Arctic stuff and extracted from it things that they thought would help them in their case now, but they stepped out of bounds in doing so. And it does appear that they chose expediency to get the case forward and indict Comey just 5 days before the statute of limitations expired on the charge. They chose expediency over careful investigative steps. If they had gone about this in the correct and careful way, they would not be in this situation. Hence, on the very day discovery was due, suddenly filing a motion for a filter team. That should have been a filter team that should have existed 5 years ago, folks. Now it just keeps getting worse. Probably because they didn't go about this the right way, the investigative team here made some serious missteps. The lead FBI agent on the case was exposed to attorney-client privileged information, something that never should have happened. He then, shortly after being exposed to that information, which he should not have known about, served as the only witness to the grand jury. After testifying to the grand jury, the Office of Legal Counsel at the FBI pulled him off the case because he had been exposed and was now aware of information he should not legally have been aware of. And there's reason to believe that he conveyed at least a characterization of that information he was exposed to the grand jury, which means information that the grand jury shouldn't have had informed their decision to indict, at least potentially. Let me scroll down to some more highlights. There's so many here. The government substantially relied on statements involving Comey and Richmond in support of their proposed indictment here. And while there isn't specific regurgitation of those privileged communications to the grand jury, it doesn't appear that way. In testifying to the grand jury, both Halligan and the lead case agent referred to those statements in responses to multiple questions from the prosecutor and the grand jurors. So they still used that information. The government's position that privileged information, this is the quote, the government's position that privileged materials were not directly shared with the grand jurors ignores the equally unacceptable prospect that privileged materials were used to shape the government's presentation and therefore improperly inform the grand jurors' deliberations. And now it's going to get even worse. The court has identified, meaning Judge Fitzpatrick, in reviewing the transcript, audio recording, and all the materials at the grand jury proceeding, the court has identified two statements by the prosecutor to the grand jurors that on their face appear to be fundamental misstatements of the law and could compromise the integrity of the grand jury process. What she said is redacted. We don't know exactly what she said, but it's characterized by what Fitzgerald wrote here. It seems like after first having advised the grand jurors that the prosecutor was their legal advisor, okay, I'm going to instruct you on the law. U.S. Attorney Halligan tells them, I'm going to instruct you on the law. She then made a statement, which is redacted. And the prosecutor's statement that redacted, whatever she said there, is a fundamental and highly prejudicial statement or misstatement of the law that suggests the grand jury. It's actually, let me reread this. It's hard because of the redacted portion. Halligan's statement that redacted is a fundamental and highly prejudicial misstatement of the law that suggests to the grand jury that Mr. Comey does not have a Fifth Amendment right not to testify at trial. Huge, huge error. The prosecutor's misstatement ignores the foundational rule of law that if Comey exercised his right not to testify to the jury, that they could draw no negative inference from that decision. The prosecutor's statement that redacted may have reasonably set an expectation in the minds of the grand jurors that rather than the government bear the burden to prove Mr. Comey's guilt beyond a reasonable doubt at trial, the burden shifts to Mr. Comey to explain away the government's evidence. Second, the prosecutor told the grand jury that there was redacted. That statement clearly suggests to the grand jury that they did not have to rely only on the record before them to determine probable cause that could be assured the government had more evidence, perhaps better evidence, that would be presented at trial. Not good. And then it gets even worse. There were 2 indictments issued here. The first was a 3-count indictment, and the jury failed to return that indictment. It didn't pass. They didn't have enough votes to push that 3-count indictment for it. It failed. It's called a no true bill. But the 2-count indictment, which is the second one that was supposedly presented to the grand jury, did get a vote. It got 14 votes to bring the case forward. But there's an issue with this process. The second indictment was a new indictment, and therefore the undersigned concluded after reviewing the grand jury transcript, I mean, the judge looked at this, he concluded after reviewing the grand jury transcript that the prosecutor would have presented the second indictment to the grand jury for consideration before it was returned in open court, but it now appears that may not have happened. The short time span between the moment the prosecutor learned that the grand jury rejected 1 count in the original 3-count indictment and the time the prosecutor appeared in court to return the second indictment could not have been sufficient to draft the second indictment, sign the second indictment, present it to the grand jury, provide legal instruction to the grand jury, and give them an opportunity to deliberate and render a decision on the new indictment. So it looks like she took the 3-count indictment. It returned a no true bill. It doesn't pass. And it looks like what she did was remove one of the counts that was the problematic one for the grand jury, and then either have them just vote again without representing the indictment, or something screwy happened. And if this procedure, if this did not go down the way that is very strictly controlled and prescribed to go down in a grand jury process, if the grand jury process was not followed, then the judge here is in uncharted legal territory, and that the indictment returned in open court was not the same as the charging document presented to and deliberated upon by the grand jury. When prosecutorial misconduct before the grand jury prejudices a defendant and threatens the defendant's right to fundamental fairness in the criminal process, a district court may exercise its supervisory authority to dismiss that indictment. Here, the procedural and substantive irregularities that occurred before the grand jury and the manner in which evidence presented to the grand jury was collected and used may rise to the level of government misconduct, resulting in prejudice to Mr. Comey. The judge then came up with 10 findings. Actually, it's 11 findings. That's a typo. 11 findings and a conclusion about this case, or about what he had looked here. First, the facts establish a reasonable basis for the defense to challenge whether the Richmond warrants were executed in a manner consistent with his Fourth Amendment rights and consistent with the orders of the court that issued those search warrants. Second, the facts establish a reasonable basis for the defense to challenge whether the government exceeded the scope of the Richmond warrants. Third, the facts establish a reasonable basis for the defense to challenge whether the government had the lawful authority to search the Richmond materials. Fourth, the facts establish a reasonable basis for the defense to challenge whether the government's 2025 seizure of Richmond's materials included information beyond the scope of the original warrants. Fifth, the nature and circumstances surrounding the government's potential violations of the Fourth Amendment and court orders establish a reasonable basis to question whether the government's conduct was willful or in reckless disregard for the law. Sixth, the facts provide a reasonable basis for the defense to show that they were prejudiced by the government's use of the Richmond materials in the grand jury. Seventh, the facts establish a reasonable basis for the defense to challenge whether the government took sufficient steps to avoid the collection and review of privileged materials, including the reason why Comey was never afforded the opportunity to assert a privilege over those communications until after there was an indictment. 8th, the facts establish a reasonable basis for the defense to challenge whether privileged information was used directly or indirectly by the government to prepare and present to the grand jury. 9th, the nature and circumstances surrounding the disclosure of potentially privileged information establish a reasonable basis to question whether the government's conduct was willful or in reckless disregard of the law. 10th, as discussed in section 4 of the memo here, above the prosecutor made statements to the grand jurors that could reasonably form the basis for the defense to challenge whether the grand jury proceedings were infected with constitutional error. 11th, the grand jury transcript and recording likely do not reflect the full proceedings because, although it is clear that a second indictment was prepared and presented to the grand jury, the transcript and audio recording of the proceedings do not reflect any further communications after the grand jury began deliberating. And if you were with me for a previous video where we went through filings to Judge Curry about grand jury proceedings and how the grand jury went down, because Judge Curry had said at a hearing last week that it looks like some of the minutes are missing because the grand jury meets from like 2:30 to 4:30. And then there's 2 hours of nothing. And then at 6:40, suddenly there's an indictment and the process and they go and file the indictment. Actually, they filed both of them, right? The one that failed and the one that passed. But there's a 2 hour gap where there's nothing on the transcripts. In her motion, there was a clarification motion or clarification notice to Judge Curry. Lindsay Halligan said that 2 hour gap is when the grand jury deliberated. But that indicates that there was the 1 2 hour presentation and then the 1 2 hours of deliberation. And yet we have a failed grand jury indictment and a passed one. How can there be those two things out of only one presentation and one period of deliberation? It should be present, deliberate, fail, and then present, deliberate, pass. Collectively, the facts set forth herein and the particularized findings of the court establish that grounds may exist to dismiss the indictment because of matters that occurred before the grand jury. Therefore, Judge Fitzgerald found that, the grand jury material should be disclosed to Comey's team, and they can go through it, and then they can file their motion to dismiss if they want to, based on those. Now, immediately after this, hours later, emergency motion to stay was filed, and as I told you earlier, the judge went ahead and agreed on that, but on a very expedited timeline, and it would appear that he agreed to it because Comey's team said they would agree to it. Messed up my the thread jumped back to the top. Comey's team at the end of their oppositional filing said this: to the extent that the court is inclined to grant a stay, the defense requests an expedited briefing schedule, and that would basically be, let's handle this week. Prosecution wanted to have until November 24th to file their first brief on this, their first objection. What the judge ended up ordering, he said it's granted in part. He granted DOJ's motion to stay in part. And the in part aspect to this is that he basically granted the order to stay, but he also granted defense's schedule plus about 24 hours. So Wednesday, the government has to file their objections. Comey's team has to respond by Friday of this week, and then Judge Nachmanoff is going to handle it. So, big win for Comey. Actually, I would say a huge win for Comey. And this is a ugly, ugly mess for DOJ to sort out. Maybe they can. maybe they can, guys. Maybe Halligan's team, they've got an explanation for every one of the findings that Judge Fitzgerald has here, right? Maybe they do. And they can explain every little thing. They can articulate how Fitzgerald misunderstood the process, misunderstood what Halligan said, all of that. Maybe they can, but I doubt it. And if they can't, well, I think the judge is going to find that there's enough of a basis here to turn disclose these materials to Comey, no matter what. I think the judge is going to find that there's enough irregularities here. There's enough reasonable basis and particularized evidence to justify breaking grand jury secrecy and disclosing all the materials to Comey's team for them to go through and see if they can construct motions to dismiss one or more out of the grand jury materials. So this isn't going away. But the explanation for all of these irregularities and this apparent misconduct and misstatements of the law and privilege spill and all of these things, maybe there's a really good explanation or series of explanations that Halligan's going to come up with. And this case will survive this challenge. However, it is not looking good for DOJ here. It's not looking good for Halligan. If you're interested in this case, I'm keeping track of it filing by filing. Thank you for joining me. Hit like, subscribe. Let me know in the comments what you think about the status of this case, what position it's in, what position each side is in, whether you think the case against Comey is going to survive a disclosure of grand jury materials, whether you think Halligan's going to get dismissed as the U.S. attorney. I'm interested to know your thoughts on this case. All right, I'm going to go record more videos about more developments in the case, and I'll see you on the next one. All right, document nerds, let's get into the Comey docket and look at these latest filings. There are going to be, let's see, 1, 2, 3, 4, 5 filings that we're going to look at now. Now, if you hopefully by this point in the podcast, you've already watched this segment where I introed what was going on. I gave background on what's going on here. I do need to make a correction. One of my followers, let me go to my replies and find it. Yeah, Christine left me a comment on X that, I misspoke or I mischaracterized how the grand jury process worked a bit in that video, where the prosecutor doesn't go to them and say, here's what I want. And I think I may have characterized it that way in the video, so I need to make a correction on that. That is not the case. We're going to get the issue there is, of course, the process that returned these 2 indictments, but it seems like there was only 1 2-hour presentation and then 1 session of deliberations that also went on for 2 hours. But yet 1 no true bill was returned. That was the 3-count indictment. And then the other true bill, which was the 2-count indictment. And sincerely, I don't know if that's unusual, but it seems like it would be unusual. And my reading of both comments on it from Judge Curry and then what Fitzgerald had to say here, they were both perplexed by it. And that's led the judge to write part of this order, or the memo. He goes into what's confusing about it, and I'll get there eventually in this, but I wanted to go ahead and correct that. I've never had a grand jury process in any case I've covered. I've never had an examination of the grand jury process come up in this way. I do know that it's very rare that a defendant is able to successfully challenge the grand jury process and get disclosure on it. And I would guess even more rare that leads to a dismissal. However, there seems to be a there when it comes to this. However, there was a question about the grand jury process like several documents ago, several filings ago, maybe 2 dozen ago. And there was it was in front of Judge Curry, where she said that it seemed like the documents that they had filed for the grand jury seemed incomplete. And then soon after, DOJ, through AG Bondi made a filing, and then also Halligan made a filing trying to clarify, right there, clarifying the record as to how it went down. And Halligan gave an affidavit where she said that I only went in front of I presented it to the grand jury one time. There was nothing missing. There was no additional presentation or interaction or discussion outside of what is reflected in the transcript. The time period that stops at 4:28 p.m., I think thereabout. Yeah, 4:28 p.m. That's when the grand jury began their deliberations. And that clarified a question that had been initially raised by the defense, in that it seemed like the grand jury was kept well past closing time of the court. They were kept until 6:40. So they raised the question of, did the jury feel pressure to return an indictment on that day, since they kept them far past regular hours? The answer to that is no, because now we understand that the time period between 4:28 p.m. and 6:40 p.m. was when the grand jury was deliberating. But what's weird is that they then go to, when they got done, it says, I was notified by then a first assistant attorney Maggie Cleary that the grand jury had returned a true bill as to the presented count 2 and count 3 of the indictment, and that the grand jury had not returned a true bill as to the presented count 1. I then proceeded to the courtroom for the return of the indictment from the magistrate judge. During the intermediate time between concluding my presentation and being notified of the grand jury's return, I had no interaction whatsoever with any members of the grand jury. This time represents the grand jury's private deliberations, which was done in secret with no one but the members of the grand jury present. So what's confusing to me is that, and what was confusing to the magistrate judge who received the indictment of Comey, is that Halligan filed the 3-count and it said no true bill, but then she filed a different 2-count indictment that was true bill. And both are signed by Halligan and both are signed by the foreman of the grand jury. And so far, 2 magistrate judges and then a senior district judge have all looked at this proceeding and the documents associated with this grand jury proceeding and have questioned it. So that's why I'm saying there seems to be a there. However, the one question about it, one seeming irregularity about it, has been clarified. Maybe the rest of this can be clarified. I'm open to it. Okay. Here is the Magistrate Judge Fitzgerald's memorandum and opinion, and it is quite extraordinary. Some say it's extraordinary because it's so far out of bounds and he's a crooked judge and he's a deep state or friends with Comey and all of these things, and they're assigning malice to it. I'm not ready to do that. They're assigning incompetence or something. I'm not going to go there without evidence to that effect. I'm just going to go with what the filing, what documents in the case say, and if there is some sort of conflict or something unjust or something going on here, we'll figure it out through the documents. Okay. We already know the matter before the court, and it has to do with Federal Rule of Criminal Procedure 6 and grand jury secrecy. For the reasons set forth below, the court finds the record in this case requires the full disclosure of grand jury materials. This is the second time he's ordered this. And so finding, the court recognizes this is an extraordinary remedy, but given the factually based challenges the defense has raised to the government's conduct and the prospect that government misconduct may have tainted the grand jury proceedings, disclosure of grand jury materials under these unique circumstances is necessary to fully protect the rights of the accused. We don't really need to go through the procedural history because we've already discussed it previously in this show and in others. And if you're watching this, you're probably up to speed on all of that. I wish others who were commenting on the case were up to speed on that. Legal standard, long established policy of maintaining secrecy of grand jury proceedings. We got a lesson in that over the summer, didn't we? With the filings to disclose grand jury materials in both of Epstein's federal cases and in the Maxwell case, right? So we're going to skip that. Okay, factual background. In 2017, the U.S. Attorney's Office for the District of Columbia initiated an investigation referred to by the FBI as Arctic Haze. This investigation concerned an allegation of unauthorized disclosure of classified information to a New York Times reporter, which appeared in an April 22nd, 2017 article titled, quote, "Comey tried to shield the FBI from politics, then he shaped an election." The investigation focused on the article's inclusion of classified information related to one of the factors that influenced Mr. Comey's decision. As then FBI director, to unilaterally announce the closure of the FBI's investigation into then presidential candidate Hillary Clinton and her handling of classified material while she was serving as Secretary of State. Daniel Richman, a Columbia Law School professor, personal friend of Comey, and former special government employee at the FBI during Mr. Comey's tenure as FBI director, was quoted by name in the article and was subject to the U.S. Attorney's Office for D.C.'s investigation. The Richman search warrants. In 2019 and 2020, the FBI obtained 4 warrants authorizing agents to search a hard drive, an iCloud account, an iPad, and iPhone belonging to Mr. Richman, as well as 2 Columbia University email accounts used by Mr. Richman. These are going to be collectively referred to as the Richman warrants. And then we have the 4 of them here. I have looked to try and find these search warrants on Court Listener. I have not found them. Trying to learn more about them. I haven't found anything else about them. But for the first time, we have them listed here. And the first one was on August 27th, 2019, and it was for Richman's hard drive. And the period that it was for Richman's hard drive was February 1st, 2017 to April 30th, 2017. The next search warrant was October 22nd, 2019, and authorized a search of Richman's Columbia University and Law School email accounts from March 1st, 2016 and May 30th, 2017. So a much greater period, and it goes way further back. The next search warrant was issued in January 31st of 2020 and authorized a search of Mr. Richman's iCloud account from that same period, March 1st, 2016 to May 30th, 2017. And then it says attachment B to the warrant specifically limits the information to be seized to non-privileged communications. The next search warrant, and the last one, was on June 4th, 2020, authorized a search of the backup files for Mr. Richman's iPad and iPhone for that same period, March 1st of 2016 to May 30th, 2017. And the same thing, it had an attachment B that limited it to non-privileged communications. So this first search warrant, issued in August 2017, was for Richman's hard drive and was specifically for February 1st of 2017, April 30th to 2017. The other ones went all the way back to March 1st, 2016. Okay, the Richman warrants authorize agents to search for and seize information created or stored between March 1st, 2016 and March 30th, 2017 that constituted evidence of 2 different crimes. 18 U.S.C. 641, which is theft and conversion of stolen government property, and 18 U.S.C. 793, which is unlawful gathering or transmission of national defense information. The information seized pursuant to the Richman warrants during the Arctic Haze investigation is at the center of the current dispute between the parties in this case. The 2019 and 2020 searches of the Richman devices as part of Arctic Haze. The record reflects that in 2019 and 2020, the government took modest and, as it turned out, ineffective steps to identify and isolate potentially privileged information contained in the material seized pursuant to the Richman warrants. For example, the government permitted Columbia University to review the emails seized from Mr. Richman's Columbia email accounts and withhold private or otherwise sensitive communications. The government also provided Mr. Richmond and his counsel with an opportunity to review the material seized from his devices and to assert privilege over those materials. The government claims that the documents and communications identified by Columbia University and Mr. Richmond as privileged were never reviewed as part of the Arctic Haze investigation. However, the government never engaged Mr. Comey in this process, even though it knew that Mr. Richmond represented Comey as his attorney as of May 9th, 2017, the day Trump fired him. And 3 of the 4 Richmond warrants authorized the government to search Mr. Richmond's devices through May 30th, 2017, 21 days after an attorney-client relationship had been formed. In the August 2019, which is the same month and year that the search warrant was taken out, the first one, the IG in its report noted that Mr. Comey informed the IG that, quote, the day after his removal or very shortly after, he retained attorneys Patrick Fitzgerald, David Kelly, and Daniel Richmond. So there was awareness within DOJ that Comey had these attorneys, including someone that they were taking out a search warrant on. According to an April 29th, 2020 letter from Mr. Richmond's, and this coffee's damn good. Wow. That was my first sip. So good. Thank you to everybody who's bought me coffee. According to an April 29th, 2020 letter from Mr. Richmond's then attorney to the government, produced to the court ex parte by the defense. So so that's going to be probably, there's a filing somewhere here where that we can't look at. That is, there it is, ex parte under seal. Nope, that's not it. Answer that. Well, it's not that important. There's one after the last hearing. Comey was allowed to file ex parte to this judge what they thought the grand jury materials might contain. Don't see it now. I probably skipped past it. Oh, well, it's okay. We'll go back to the filing. All right. The Department of Justice informed Mr. Richmond that the data it contained from his iCloud account extended to August 13th, 2019, well outside the scope of the warrant and well past the date on which Mr. Richmond was retained as Mr. Comey's attorney. Remember, and this is why I emphasize the date of these search warrants. This one was for February 1st, 2017 to April 30th, 2017. But it appears, based on a letter from Mr. Richmond's attorney at that time, who Mr. Richmond had retained, that DOJ collected data from his iCloud account all the way to August 13th, 2019, well outside the scope of the warrant and well past the date on which Mr. Richmond was retained as an attorney by Mr. Comey. The same letter further states that the Department of Justice informed Mr. Richmond that it had seized data from Mr. Richmond's hard drive that extended to June 10th, 2017. Again, well into the period during which Mr. Richmond represented Mr. Comey, despite the warrant imposing a temporal limit of April 30th, 2017. Uh-oh. At the time the Richmond warrants were executed, the government was aware not only that Mr. Richmond represented Mr. Comey, but also that he maintained ongoing attorney-client relationships with other individuals, as the FBI materials regarding his resignation from special government employee status noted his intention to represent a defendant in a federal criminal prosecution. As a result, when the government obtained the first Richmond warrant in 2019, it was clearly foreseeable that Mr. Richmond's devices contained potentially privileged communications with numerous third parties, including Comey. Nevertheless, in 2019 and 2020, the government made a conscious decision to exclude Mr. Comey from the filter process, even though Mr. Comey, as the client, is the privilege holder, not Mr. Richmond. The government's claim at the November 5th, 2025 hearing that Mr. Richmond at the time himself, the subject of a criminal investigation, and represented by separate counsel, was in a position to effectively assert Mr. Comey's privilege is entirely unreasonable. Another O. Of equal concern is whether the government complied with a fundamental requirement of the Fourth Amendment and with the plain language of the warrant, that it may seize only those materials specifically authorized by the court. Under long-standing Fourth Amendment precedent, the government may search for and seize only those materials expressly authorized by the terms of a search warrant issued in connection with a specific predicate offenses. I'm going to skip some of the case law right there. Here, the government was permitted to search all of the Richmond materials, but authorized to seize only evidence related to violations of theft and conversion of stolen government property, 18 U.S.C. 641, and 18 U.S.C. 793, unlawful gathering or transmission of national defense information. Both markedly different offenses than those with which Mr. Comey is currently charged. And think back to those charges. Why were they after those? They were after those because in that article right here, which I've gone over this whole article before on this show. Seems like it was a year ago. And I also went over in my favorite article I've ever done right here in February of 2023, where I found evidence of 6 journalists were part of a leak investigation that DOJ was looking into, which we now know was Arctic Haze and Siren's Lure and all these other ones that we got declassified and got disclosure on this past summer. That article has to do or contained a leak about the Renteria memo. Which also information about that came up in a Washington Post article, and that was the subject of another leak investigation. So that's why they were looking for evidence of theft and conversion of stolen government property. That would be the classified information was somehow taken from FBI, and unlawful gathering or transmission of national defense information. That information about the Russian reports and the Renteria memo and all that somehow wound up in media. There is nothing in the record to suggest the government made any attempt to identify what documents, communications, or other materials seized from Mr. Richmond constituted evidence of violations of 18 U.S.C. 641 and 793. To be clear, and by the way, there could be a record that does suggest that, but it's still within Arctic Haze materials that haven't been produced, either because they're classified or they're sealed or whatever. And we may get those. That may be what Halligan does in order to clarify all this and clean up this mess as she goes and gets those. To be clear, ensuring that agents and prosecutors seize only those things which a court has authorized is a critical early step in the execution of any warrant and an elemental responsibility of all government agents. When the undersigned questioned the Assistant United States Attorney currently assigned to this case at the November 5th, 2025 hearing as to how and whether a set of materials responsive to the Richmond warrants was identified and separated from non-responsive materials, he simply did not know. And there he's talking about either Diaz or, is it Lemon? I always forget the other guy. I feel bad now. It's Nathan. Lemons. Yeah. Remember, those are the two prosecutors who were brought in from the North Carolina office because a whole bunch of people in the Eastern District of Virginia office, a whole bunch of prosecutors there either resigned or were fired. So Halligan, after the indictment, days after the indictment, she brought in 2 prosecutors from a different district to then prosecute this case. So that's why the judge notes here in this footnote number 4, to be clear, the 2 assistant United States attorneys currently assigned to this case entered their appearances post-indictment and were not part of the Arctic Haze investigative team. So this shouldn't be read as a comment of, they're responsible, or they're idiots, or they're negligent or something. They were brought into the case late. And I think the impression I'm starting to get more and more is they were handled a very ugly mess. Following the hearing on November 5th, 2025, the court ordered the government to produce to the defense all material seized pursuant to the Richmond warrants in, quote, in whatever form it is currently maintained by 5 p.m. on November 6th. Pursuant to that order, the government provided to the defense the material seized from the Richmond warrants. But, according to the defense, the manner and format in which the government provided the information did not reflect that the government had seized, reviewed, and used only the information responsive to those warrants. This potential failure by the government is even more concerning because the warrant issued on August 27, 2019, specifically directed the government to identify what information was responsive to the warrant and instructed law enforcement personnel to then seal any information that does not fall within the scope of the warrant and not to further review the information absent an order of the court. Footnote, this provision is not repeated in the other Richmond warrants submitted by the government, but the approach is nevertheless plainly required on the face of each warrant, and as discussed supra, is in accordance with well-established Fourth Amendment precedent. And on that one in particular, it expressly made this instruction. The government appears to have conflated its obligation to protect privileged information, an obligation it approached casually at best in this case, with its duty to seize only those materials authorized by the court. This cavalier attitude towards a basic tenet of the Fourth Amendment and multiple court orders left the government unchecked to rummage through all of the information seized from Mr. Richmond, and apparently, in the government's eyes, to do so again anytime they chose. Footnote, the Fourth Circuit has held that the government's prolonged retention and continued access to materials that are non-responsive to a search warrant may violate the Fourth Amendment. Which, if that's what occurred here, that can be a basis for a motion to dismiss. It's that the government grabbed up this evidence against Comey for this indictment outside of the scope of the warrant on which they seized that evidence, which is why Comey has raised in several filings and at a hearing that his team believes there's a Fourth Amendment violation here. And that's why they wanted to challenge the Arctic Haze search warrants first before agreeing to a filter team. The Arctic Haze investigation was closed in September 2021 with no charges filed. The Richmond material sat dormant with the FBI until the summer of 2025, when the Bureau chose to rummage through them again. The 2025 search of the Richmond materials as part of the investigation into Comey. By summer of 2025, the FBI and the United States Attorney's Office for the Eastern District of Virginia had initiated a criminal investigation into Mr. Comey. As part of the investigation on September 12, 2025, an FBI agent assigned to the director's advisory team was instructed, apparently with the concurrence of the U.S. Attorney's Office for the Eastern District of Virginia, to review a Blu-ray disc that contained a full Cellebrite extraction and reader reports of Mr. Richmond's iPhone and iPad backups. Footnote 7 says, it is important to note that the U.S. Attorney's Office for EDVA prosecutors were not involved in the 2019 and 2020 searches of the Richmond materials and may have reasonably assumed the agents in 2019 and 2020 seized and preserved only those materials responsive to the warrants. Oh, lost my place for a second. All right. Inexplicably, the government elected not to seek a new warrant for the 2025 search, which could have saved their bacon here, right? They wouldn't be in, if they had done that, it would have saved them this grief. Even they didn't seek a new warrant in 2025, even though the 2025 investigation was focused on a different person and was exploring a fundamentally different legal theory and was predicated on an entirely different set of criminal offenses. The court recognizes that a failure to seek a new warrant under these circumstances is highly unusual. The court also recognizes that seeking a new warrant under these circumstances would have required a fresh legal analysis and likely resulted in some delay, a delay the investigative team could not afford, given that the statute of limitations would expire in a mere 18 days. If a new warrant had been sought by the government and issued by the court, the Fourth Amendment would have required it to be narrowly tailored, authorizing access only to the materials within a limited time frame and relevant to the new offenses now under investigation. In addition, any new warrant would have imposed strict procedural safeguards to ensure privileged information was not reviewed by the prosecution team. As a result, the parameters of the 2025 search would have inevitably have had a different and much narrower scope than the Richmond warrants. Faced with this prospect, the government chose to unilaterally search the materials that were 1. Seized 5 years earlier, 2. Seized in a separate and since closed investigation, 3. That were never reviewed to determine whether the seized information was responsive to the original warrants, 4. That were likely improperly withheld by the government for a prolonged period of time, 5. That included potentially privileged communications, 6. Did so without ever engaging the privilege holders, and 7. Did so without seeking any new judicial authority. Not good. Having decided to forge ahead under these highly unusual circumstances, the FBI agent conducting the September 12, 2025 search of the disc, that Blu-ray disc we mentioned earlier, containing information from Mr. Richmond's iPhone and iPad, was specifically instructed to seize, quote, conversations between Mr. Richmond and Mr. Comey. There appeared to be no precautions in place to avoid the collection of privileged communications. The agent conducted the review and printed the relevant pages, which included multiple conversations between Mr. Comey and Mr. Richmond. The reviewing agent then transferred the disc, the relevant printed pages, to a second FBI agent, hereinafter referred to as Agent 2. Sometime between September 12, 2025 and September 25, 2025, Agent 2 reviewed the newly seized materials and, not surprisingly, identified communications involving Mr. Comey and Mr. Richmond as potentially privileged. The government presented this case to the grand jury on September 25th. The same day, prior to the grand jury presentation, Agent 2 alerted the lead case agent, hereafter referred to as Agent 3, and an attorney with the FBI's Office of General Counsel, that, quote, evidence obtained in the government's investigation of James Comey may constitute attorney-client privileged or attorney-client confidential information. It is also possible that the agents may have obtained evidence that constitutes attorney work product information. Footnote. This is the language used by an FBI attorney to characterize their September 25 phone conversation with Agent 3. A second agent, possibly Agent 2, was also on the call, but that person's identity has been shielded from the court. Interesting. Agent 2 gave Agent 3 and the FBI attorney, quote, a limited overview of the privileged communications. Another footnote. The government provided no further detail about what, in its view, constitutes a limited overview. That's what they called it. Agent 3, rather than remove himself from the investigative team until the taint issue was resolved, proceeded into the grand jury undeterred and testified in support of the pending indictment. In fact, Agent 3 was the only witness to testify before the grand jury in support of the pending indictment. The government's decision to allow an agent who was exposed to potentially privileged information to testify before a grand jury is highly irregular and a radical departure from past DOJ practice. Big uh-oh. Only after the government had reviewed the materials seized pursuant to the 2019 and 2020 search warrants, only after FBI agents had personally identified potentially privileged materials, and only after the government obtained an indictment on September 25th, did it seek court approval of a filter protocol. That was on October 13th, the day that Rule 16 discovery was due. For reasons that remain unclear, the government waited 31 days from September 12th, the date the FBI began reviewing the materials, and 18 days from the September 25th date the FBI informed its Office of General Counsel about having been exposed to potentially privileged materials before seeking court approval of a filter protocol on October 13th. And I don't know this, but I wonder if the new assistant prosecutors that were brought in, they're not new at the job. They've been in North Carolina office for years. One of them was the chief of his section. So they're not like fresh in the U.S. Attorney's Office in North Carolina. They're experienced. I wonder if they had any idea about this and how it went down that October 13th, the due date of the discovery, was the day they asked for a filter protocol. Because it just comes across, reading the filings as we've been doing, it comes across like a scramble to try and fix this issue that had already existed for 31 days. And that they had absolutely 100% known about for at least 18 days. But it comes across like they didn't, there was missteps very early on, and missteps back in 2019, right? And then missteps here since September 12th. And then October 13th, suddenly it's like, we gotta try and fix this stuff. Let's get a filter team. And then remember, like 6 days later, they urged the judge to expedite his decision on it when the defense hadn't yet responded and had 14 days to do so. So I don't know. It just comes across to me like a scramble. All right. The court's in-camera review of the grand jury materials, which footnote, specific statements made before the grand jury are redacted. The court's analysis of those statements is not. The court has now reviewed the grand jury transcript, the audio recording of the grand jury proceedings, as well as the exhibits presented to the grand jurors. Only one witness, Agent 3, testified before the grand jury, and only one prosecutor appeared on behalf of the government. The search and use of the Richmond materials. The government's position is that the grand jury materials, quote, confirm the baselessness of the defendant's claim that privileged information may have been shared with the grand jury. While it is true that the undersigned did not immediately recognize, meaning this Judge Fitzgerald, he says he did not immediately recognize any overtly privileged communications in the transcript of the grand jury, it is equally true that the materials seized from the Richmond warrants were the cornerstone of the government's grand jury presentation. The government substantially relied on statements involving Mr. Comey and Mr. Richmond in support of its proposed indictment. Agent 3 referred to these statements in response to multiple questions from the prosecutor and from grand jurors, and did so shortly after being given a limited overview of privileged communications between the same parties. The government's position that privileged materials were not directly shared with the grand jurors ignores the equally unacceptable prospect that privileged materials were used to shape the government's presentation and therefore improperly inform the grand jurors' deliberations. Now, I've been pointing to this being a possibility that happened because you had that one agent, it's Miles Starr, testified to the grand jury as the only witness, and he was tainted by exposure to these privileged communications. Communications he never should have been able to view. And this judge, has read the transcript, has looked at the materials, and says, yeah, they didn't quote those communications verbatim, but those communications are the cornerstone of the proposed indictment. And they answered questions. Both Halligan and that agent answered questions that referred to those communications, multiple questions. They referred to the statements that they shouldn't have had access to. And it's clear that those statements, quote, were used to shape the government's presentation and therefore improperly inform the grand jury. And if an indictment is returned based on information that the grand jury never should have had access or been informed of, I think that kills it. I think that's a dead ringer for a motion to dismiss on that alone. I assume that Halligan comes in today. I think later today her filings due on this, or at a later hearing or a later filing. Assume that there's an explanation for absolutely everything. How do you get around this? Seems like a huge, huge mistake. It gets even worse, though. Statements of the prosecutor to the grand jury. Having been requested by the government to review the grand jury materials, the court has identified two statements by the prosecutor to the grand jurors that on their face appear to be fundamental misstatements of the law that could compromise the integrity of the grand jury process. Both statements by the prosecutor are in response to questions by grand jurors and are directly related to communications involving Mr. Comey. First, after having advised the grand jurors that the prosecutor was their legal advisor, the prosecutor stated, redacted. The prosecutor's statement that, redacted, is a fundamental and highly prejudicial misstatement of the law that suggests to the grand jury that Mr. Comey does not have a Fifth Amendment right not to testify at trial. Big uh-oh. The prosecutor's statement ignores the foundational rule of law that if Mr. Comey exercised his right not to testify, the grand jury could draw no negative inference from that decision. The prosecutor's statement that redacted may have reasonably set an expectation in the minds of the grand jurors that rather than the government bear the burden to prove Mr. Comey's guilt beyond a reasonable doubt at trial, the burden shifts to Mr. Comey to explain away the government's evidence. And I think from that comment right there, you can guess at what she said. He must have made some statement in response to a question about, well, that Comey will have to explain that at trial. It must have been some kind of statement along those lines, if we're to read what he's alluding to here. Cannot say that. You cannot say that. Next part. That's one huge mistake by Halligan. In addition, the statement by the prosecutor was made in response to challenging questions from grand jurors, the context of which suggests the grand jurors may have reasonably understood the prosecutor to mean that if she could not satisfactorily answer their questions, then Mr. Comey would, redacted, answer these questions at trial. And that's why I think that right there is have to. Then Mr. Comey would, quote, have to answer these questions at trial, or something to that effect. Second, the prosecutor told the grand jury that there was redacted. Don't know what that is. That statement clearly suggests to the grand jury that they did not have to rely on the record before them to determine probable cause, but could be assured the government had more evidence, perhaps better evidence, that would be presented at trial. Cannot do that. They have to find probable cause based on the government's presentation. Not good at all, folks. And the judge he has a transcript and an audio recording. So I don't know what explanation could explain that away, unless like they're going to say the court recorder made a mistake or something. Maybe there's a misunderstanding. I'm open to it, but looks bad. Looks real bad. All right, next part. Issues regarding the completeness of the grand jury transcript and audio recording and the manner in which the second indictment was presented to the grand jury. Finally, the record is well established that the grand jury was originally presented with a 3-count indictment. It was signed by the prosecutor. The grand jury, however, rejected count 1 of the original indictment and found probable cause as to the 2 remaining counts. At some point, the prosecutor prepared and signed a second indictment that removed count 1 of the original indictment. At the return of the indictment, the government presented both the first and the second indictments to the magistrate judge. The first indictment indicated the grand jury failed to find probable cause as to any count. The second indictment indicated that the grand jury found probable cause as to 2 counts. Both indictments were fully executed by grand jury foreperson and the prosecutor. Presented with 2 facially inconsistent indictments, the magistrate judge, who on September 25th was receiving these, questioned the grand jury foreperson and the prosecutor to unwind this procedural knot. The magistrate judge then accepted the return of the second signed indictment. The second signed indictment was a new indictment and was therefore, the undersigned concluded, this judge, after reviewing the grand jury transcript, that the prosecutor would have presented the second indictment to the grand jury for consideration before it was returned in open court. It now appears that may not have happened. On November 14th, 2025, the prosecutor filed a declaration with the court attempting to address the issue of whether the transcript of the grand jury proceedings filed with the court was full and complete. The prosecutor stated that after the grand jury was left to deliberate on the first indictment at approximately 4:28 p.m., she had no further contact with the grand jury. The prosecutor further stated that at approximately 6:40 p.m., she was notified by then First Assistant United States Attorney that the grand jury returned a true bill on only 2 of the 3 counts presented by the government. Footnote: if the court is to read the prosecutor's declaration as suggesting there was no contact between any government official and the grand jury after 4:28 p.m., then it begs the question of how the then First Assistant U.S. Attorney learned that the grand jury had refused to indict on 1 count, and how the First Assistant knew which count had been rejected by the grand jury, all before the indictment was returned in open court. The prosecutor, according to her own declaration, then proceeded to the courtroom for the return of the indictment. The hearing on the return of the indictment began at approximately 6:47 p.m., so 7 minutes later. The short time span between the moment the prosecutor learned that the grand jury rejected 1 count in the original indictment and the time the prosecutor appeared in court to return the second indictment could not have been sufficient to draft the second indictment, sign the second indictment, present it to the grand jury, provide legal instructions to the grand jury, give them an opportunity to deliberate, and render a decision on the new indictment. If the prosecutor is mistaken about the time she received notification of the grand jury's vote on the original indictment and this procedure did take place, then the transcript and audio recording provided to the court are incomplete. If this procedure did not take place, then the court is in uncharted legal territory, in that the indictment returned in open court was not the same charging document presented to and deliberated upon by the grand jury. Either way, this unusual series of events, still not fully explained by the prosecutor's declaration, calls into question the presumption of regularity generally associated with grand jury proceedings, and provides another genuine issue the defense may raise to challenge the manner in which the government obtained the indictment. And that's what I was referring to here. And my question to Christine, like, we've got the magistrate judge that was there that day, confused by the manner in which the indictment was returned and the fact that there was a no true bill accompanying it. And then Judge Curry, when she looked at this, said the record seemed incomplete. And so Halligan and Bondi made more filings, and Halligan made that declaration trying to clarify the record. And then now this judge is like, this seems not right. Maybe there's an explanation. I don't know. All right, next part. Authority that may support a defense motion to dismiss. To secure the disclosure of grand jury materials under Rule 6E3E2, a defendant must show that, quote, a ground may exist to dismiss the indictment because of a matter that occurred before the grand jury. All right, I'm going to pause. I think that's well established here. It's not that there is something here to dismiss it. It's just a ground may exist to dismiss the indictment because of a matter that occurred before the grand jury. I think we have that here in multiple places. The government argues that the defense has failed to meet its heavy burden to satisfy this standard, and even assuming there was a Fourth Amendment violation or a series of Fourth Amendment violations as it appears, or that privileged information was compromised, the most severe remedy available to the defense would be the exclusion of evidence rather than dismissal of the indictment. Indeed, the validity of the indictment is not affected by the character of the evidence considered, according to United States v. Calandra, 1974. Courts have likewise held that the grand jury's consideration of evidence obtained in violation of attorney-client privilege on its own does not constitute grounds for a dismissal of an indictment. So, hey, even if there were those two screw-ups, doesn't necessarily mean the whole thing must be dismissed. However, the government's claim that this is, at worst, a conventional Fourth Amendment violation and an excusable slippage of privileged communications is unpersuasive, particularly considering the central role this information played in the government's grand jury presentation. It is well established that courts may, and indeed on occasion must, use their supervisory authority to safeguard the integrity of the grand jury process. The Supreme Court has recognized that a district court may use its supervisory power, quote, to dismiss an indictment because of misconduct before the grand jury, at least where that misconduct amounts to a violation of one of those few clear rules which were carefully drafted and approved by this court and by Congress to ensure the integrity of the grand jury's functions. That's from United States v. Williams, 1992, also United States v. Mechanic, 1986. The Supreme Court has also recognized that this supervisory power of federal district courts should be used, quote, to implement a remedy for violations of recognized rights, to preserve judicial integrity by ensuring that a conviction rests on appropriate considerations validly before the jury, and finally, as a remedy designed to deter illegal conduct. United States v. Hastings, 1983. Accordingly, when prosecutorial misconduct before the grand jury prejudices a defendant and threatens the defendant's right to fundamental fairness in the criminal process, a district court may exercise its supervisory authority to dismiss the indictment. United States v. Derrick, 1998. And at this point, my first reading of this, when I read the magistrate judge write that, I thought, he's there. I think this judge is there. If that was before him, I think he feels compelled to dismiss the indictment. That's just my thoughts, my opinion. But I think he's there. He's not. That's not before him though, so he's not dismissing it here. He can't. But like I said earlier, there's a there there. The Supreme Court has held that a defendant who seeks to have an indictment dismissed because of misconduct before the grand jury must show actual prejudice and establish that the violation substantially influenced the grand jury's decision to indict, or that there is grave doubt that the decision to indict was free from the substantial influence of such violations. Here, the procedural and substantive irregularities that occurred before the grand jury and the manner in which evidence presented to the grand jury was collected and used may rise to the level of government misconduct, resulting in prejudice to Mr. Comey. Now, here's the findings by Magistrate Judge Fitzgerald. Based on the foregoing, the court makes the following findings. First, the facts establish a reasonable basis for the defense to challenge whether the Richmond warrants were executed in a manner consistent with the Fourth Amendment and the orders of the issuing court. I'm convinced of that. Are you? Second, the facts establish a reasonable basis for the defense to challenge whether the government exceeded the scope of the Richmond warrants in 2019 and 2020 by seizing and preserving information that was beyond the scope of the warrants. That is, information that did not constitute evidence of violations of either 18 U.S.C. 641 or 793. Third, the facts establish a reasonable basis for the defense to challenge whether the government had the lawful authority to search the Richmond materials anew in 2025. Fourth, the facts establish a reasonable basis for the defense to challenge whether the government's 2025 seizure of the Richmond materials included information beyond the scope of the original warrants. I mean, I'm there on that for sure. Fifth, the nature and circumstances surrounding the government's potential violations of the Fourth Amendment and court orders establish a reasonable basis to question whether the government's conduct was willful or in reckless disregard of the law. Sixth, the facts provide a reasonable basis for the defense to show that they were prejudiced by the government's use of the Richmond materials in the grand jury, particularly if the government's conduct was willful or reckless, given the centrality of these materials to the government's presentation. Seventh, the facts establish a reasonable basis for the defense to challenge whether the government took sufficient steps to avoid the collection and review of privileged materials, including the reasons why Mr. Comey was never afforded the opportunity to assert a privilege over his communications until after the indictment was obtained. I agree. Eighth, the facts establish a reasonable basis for the defense to challenge whether privileged information was used directly or indirectly by the government to prepare and present its grand jury presentation. This is particularly troublesome because the government's sole witness before the grand jury was exposed to a, quote, limited overview of privileged materials shortly before he testified. I absolutely agree with that. Ninth, the nature and circumstance surrounding the disclosure of potentially privileged information establish a reasonable basis to question whether the government's conduct was willful or in reckless disregard of the law. This is particularly significant because Agent 3, after having been exposed to potentially privileged information, chose to testify to the grand jury rather than separate himself from the investigation. To contain any further exposure to privileged information and limit any prejudice to Mr. Comey. And he was later pulled, it doesn't say it here, but he was pulled off the case right after this. The Office of Legal Counsel pulled him because of the exposure. 10th, as discussed in Section 4 above, the prosecutor made statements to the grand jurors that could reasonably form the basis for the defense to challenge whether the grand jury proceedings were infected with constitutional error. And finally, 11th, the grand jury transcript and recording likely do not reflect the full proceedings because, although it is clear that a second indictment was prepared and presented to the grand jury, the transcript and audio recording of the proceedings do not reflect any further communications after the grand jury began deliberating on the first indictment. Collectively, the facts set forth herein and the particularized findings of the court establish that, quote, grounds may exist to dismiss the indictment because of a matter that occurred before the grand jury. The court, which that's the exception to Rule 6E, grand jury secrecy. That's one of the exceptions to it. The court need not now determine whether any facts herein have been proven or whether there is merit to any motion yet to be filed. That task may lie ahead. Rather, the court is finding that the government's actions in this case, whether purposeful, reckless, or negligent, raise genuine issues of misconduct, are inextricably linked to the government's grand jury presentation, and deserve to be fully explored by the defense. Makes perfect sense to me, guys. I think we're absolutely there on disclosure of this stuff to the defense so they can examine it and then build a motion to dismiss if they so choose, or multiple ones, so they can file motions to suppress, whatever. But we're definitely there to the point of grand jury disclosure. And I'm going to take a minute just to opine on some things I've seen. I've seen others online, other accounts and news media, insult this judge and accuse him of things. And I saw one prominent person call this order in this memo insane. And I just don't know how you read this order in this memo and then conclude that it's insane. I just think it's so unfair. And it's, for me, as someone who's just following the document and then trying to understand, it just looks like, it just looks so reactionary and performative and I guess shallow. Like the level of effort that you would have, or it either shows like just extreme partisanship that leads to a disregard for what's actually going on, or that person's effort into investigating this and learning why such a memo and order were issued is so low. They put such little effort, if any, into actually looking at it, that it's, I don't know what to say. It disappoints me when I see that kind of stuff and how that kind of reaction to this, whether it's this case or any other. I felt the same way about stuff in Trump's case, where people would react one direction or the other. And it was just so partisan and low effort. And we saw the same thing earlier this summer with the grand jury stuff and trying to get grand jury stuff unsealed that related to Epstein and Maxwell. Like, I don't know. It's just, it's over and over again. It seems like some of the most low effort, low information, and high reactionary takes. That's what's most popular, and that's what is most spreadable online. And that's what gets the clicks and the outrage. And not only do I find that kind of thing disappointing and annoying, I find it insulting, because I just see it as insulting to the reader or the listener, right? Like, they think so little of you in the audience that they're going to feed you that type of just junk. And yeah. And it's been this has been a lesson I've been a long time in learning, and that's how I ended up here, where I go through the documents and I take the time to go through these things. And it's partly what motivates me to share it with you and to do these long episodes and these examinations of what's actually in the documents and read them over and over again and pick them apart, is because you start figuring out just how many very popular accounts and very popular media outlets, whether the left or the right, they all do it. How disrespectful they are of their audience, and how disrespectful they are of the facts and the truth, and how it's all about conning you into reacting and getting clicks and views and going viral and all these things. And we find over and over again when we go into the documents and we follow things more carefully that the reactionary takes are usually off. And sometimes they just look stupid. And here with this, I mean, I think that what Judge Fitzgerald has found here, what he's ruled based on everything in front of him, it seems completely reasonable that he concludes, one, that he made these filings, and that two, that he concludes yet again that there's a particularized and factually based showing by the defense and in the materials that he's looked at in camera, this grand jury proceedings and the materials associated with it should be exposed, that the secrecy of the grand jury has been pierced, and there's a basis for it. And whenever I see these accounts and these media outlets just toss out, well, the judge is crooked because he made a decision that may benefit Comey, therefore he's a bad judge and he's corrupt and all these things. It's just such a low IQ and low effort take, but it's a very popular one. And ultimately that makes me sad. This is just, this is so much more nuance here. And it doesn't mean that I characterize it as a huge Comey win, because it is. It's a huge win for Comey. That the judge, yet again, the judge actually looked at this stuff and said, yeah, actually there is a basis here for disclosure. That's a huge win for Comey. But he hasn't got them yet. He hasn't got the materials yet because the government came in, Halligan came in, and filed this emergency motion for stay, which we're going to get to next. Emergency motion. There we go. I got it zoomed in right. Pursuant to Federal Rule of Criminal Procedure, Procedure 59A, which allows the government to serve and file objections to any order within 14 days after being served with a copy of the written order of the oral order. The government respectfully requests the court stay the magistrate judge's order pending this court's consideration of timely objections by the government. They're saying, oh, we object to this order and we're asking that it be stayed so that we can file those objections. The rule actually gives them 14 days to do that. They're asking for 1 week up until November 24th, 2025. They give background here. We already know the background. Their argument is, now remember, we just looked at 11 findings and a conclusion. Very thorough, devastating memorandum from the judge, which I didn't read it. The actual order that accompanied that memorandum is that the government should disclose to the defense all grand jury materials filed in the docket under seal by the government, that they should give them all the audio of the grand jury proceedings, and that was all supposed to happen November 17th. The first one by 3 p.m., the other one by 5 p.m. Didn't happen, but that was the order. And then order that the clerk shall file in the public docket a version of the memorandum, which we just read, and it had to have redactions over some pieces of it, and that the clerk has to maintain an unredacted version under seal. So one day we'll get to see what's under those redactions. All right. They want, Halligan asked for a stay of it because under Rule 59, a district judge may refer to a magistrate judge for determination of any matter that does not dispose of a charge or a defense. That's how that's the magistrate judge got brought in. After the magistrate judge enters on the record an oral or written order, A party may serve and file objections within 14 days. The district judge must consider timely objections and modify or set aside any part of the order that is contrary to law or clearly erroneous. The long-established policy of maintaining the secrecy of a grand jury proceeding is codified in Federal Rule of Criminal Procedure 6E. The rule provides just 3 circumstances in which a court may lift the veil of secrecy, and the defendant's motion for disclosure relies on only one, which is it allows for that exemption is for the court to authorize disclosure of grand jury matter, quote, at the request of a defendant who shows that a ground may exist to dismiss the indictment because of a matter that occurred before the grand jury. Like I said, I think we're there. There were several findings there that were, I think, 100%. 100%. I'm there with with Fitzgerald on. The exception in Rule 6E3E2 is, quote, is not an invitation to engage in a fishing expedition to search for grand jury wrongdoing and abuse when there are no grounds to believe that any wrongdoing or abuse occurred. Because grand jury proceedings are entitled to presumption of regularity, a defendant seeking disclosure of the grand jury information under the rule bears the heavy burden of establishing that particularized and factually based grounds exist to support the proposition that irregularities in the grand jury proceeding may create a basis for dismissal of the indictment. I think we're there. And I don't know how anybody argues that we're not there on that, based on what we know. The desire to investigate whether any grand jury impropriety has occurred is insufficient to rebut the strong presumption of regularity in grand jury proceedings. In deciding whether to release the grand jury materials, courts must balance the petitioner's need for release against the traditional public interest and that reason for grand jury secrecy. And only in those cases where the need for disclosure outweighs public interest and secrecy will the requirement of particularized need for release be found to exist. The government's position is that disclosure of the grand jury materials is not warranted under the facts presented to the magistrate judge. Indeed, the government believes the magistrate judge may have misinterpreted some facts he found when issuing the latest order to release the grand jury materials. That's a lot of misinterpretations. I could buy maybe a couple things. Got misinterpreted, misunderstood, but all of them did. All 11 findings. For instance, whether the defendant has any standing to challenge the Richmond materials, the full context of the statements made by the prosecutor to the grand jury, that Agent 3 was exposed to potentially privileged material, and that 2 indictments were presented to the grand jury. Additionally, the magistrate judge acknowledges, quote, he did not immediately recognize any overtly privileged communications. The possible exposure of privileged materials to the grand jury was the primary focus of magistrate judge's inquiry. Having seemingly settled that issue, the magistrate judge turns to premature issues such as suppression that have not even been briefed by the parties. For the reasons stated herein, the government respectfully requests the court stay the magistrate's order pending this court's consideration of timely objections. All right. I just think that's weak. I just think that's weak. This is the only thing in here that is really trying to say is really an argument, right? The only part of this that's an argument is just one paragraph. Everything else is just quoting the relevant law and the circumstances and all those things, right? This paragraph is basically the only part of this filing, this 7-page filing, that argues against the memorandum. And the argument it presents is, nope, the magistrate judge misinterpreted some facts. And then it doesn't even address all the findings. It addresses standing of the defendant, 1, to challenge the Richmond materials. And then the full context of the statements made to the grand jury. So 2, the exposure of potentially privileged information to Agent 3. So that's 3 issues. And then the 2 indictments were presented to the grand jury. 4. There were 11 findings. And the judge thoroughly went through them all. So to me, that's why I say I think it's a weak motion to stay. Doesn't mean it's not appropriate to stay. And I only say I don't mind it. I don't mind it being stayed because I like this case going on, right? I like following this case. So I don't exactly mind it continuing. Now, she does win. Okay? She does win out. And the motion or the order is stayed. But here is the opposition to the motion for stay. First, they praise Judge Fitzpatrick's order. Motion for stay should be denied, but to the extent the court is inclined to grant such a stay, the court should order an expedited 2-day briefing schedule. That's what Comey's team came back with. They make an 8-page filing, and they go point by point. They go point by point right here as to why it should not be stayed and how the motion for a stay is not sufficient. To get a stay, the court must consider the following factors. 1, whether the applicant, the person asking for the stay, the party asking for a stay of the order, has made a strong showing that it is likely to succeed on the merits. Well, we don't have that. We have that one paragraph, and they say the judge misinterpreted facts. But they don't go on to show how that misinterpretation, what that is. Now, of course, they're going to have more to say, but in their motion for a stay, they don't make that effort. 2, whether the applicant will be irreparably injured absent a stay. They don't address that at all. Whether the issuance of a stay will substantially injure other parties interested in the proceeding. I guess you could say they bring up the grand jury secrecy and how it's important, but we already know that, and they bring up the exception to it and then say, the judge it's not there yet. 4, where the public interest lies. They raise that, but they don't make an argument as to how disclosure of these grand jury materials to Comey is going to harm public interest or harm the grand jury or anything like that. The government has not demonstrated that it is likely to succeed on the merits of its appeal. On appeal, the district judge must consider timely objections and modify or set aside any part of the order that is contrary to law or clearly erroneous. A magistrate judge's order is clearly erroneous only when the reviewing court on the entire evidence is left with a definite and firm conviction that a mistake has been committed. A magistrate judge's order is contrary to law when the order fails to apply or misapplies relevant statutes, case law, and rules of procedure. Here, Judge Fitzpatrick's opinion carefully and exhaustively reviewed the relevant law, made factual findings, and found that, quote, the procedural and substantive irregularities that occurred before the grand jury and the manner in which evidence was presented to the grand jury was collected and used may rise to the level of government misconduct resulting in prejudice to Mr. Comey. Finding 9 separate bases for believing that the government's extraordinary misconduct may provide a basis to move to dismiss the indictment. That's why I pointed out how they found, okay, there was like 1, 2, there's 1, 2, 3, 4. They addressed 4 things, 4 findings by Patrick in their argument in this paragraph. And they labeled it all just facts misinterpreted. But they didn't go on to untangle that. And they left out the 5 other separate bases for piercing the secrecy of the grand jury and getting disclosure. So that's why I say it's weak. This is actually a very convincing motion here, where they pick it apart. But this episode's going on pretty long, and I want to get to at the end and show you something. In sum, because the government has proffered no basis to believe that it has a reasonable likelihood of success, remember that was point one of what they have to do to get a stay, and because the government's proposal injects further delay that poses an obstacle to the orderly disposition of the threshold legal issues that must be resolved before trial can commence, and trial is 2 months away, the motion for a stay should be denied. To the extent, however, the court is inclined to grant a stay, the defense requests an expedited briefing schedule given the proximity of the trial date and the significant government misconduct apparent from Fitzpatrick's opinion. The government's motion should be due November 18th at 5 p.m., and the defense's opposition should be due November 19th at 5 p.m., which is today. So they said, Comey's team said, look, if you're going to grant this stay, give them 24 hours and give us 48 hours to get it done, instead of the 14 days, which the judge could give. All right, so this is what Judge Nachmanoff, and that's who's dealing with this because he's the district judge over the case. So because it's a motion for stay from an order of the magistrate judge, it's the handling of this is up to Judge Nachmanoff. So Nachmanoff come back and says, hey, we got this matter before the court. I'm going to order that the motion is granted in part. Order that the government will file any objections by 5 p.m. Wednesday. So he gives the government, Halligan, he gives them 48 hours to file their objections. Defense will have until Friday to file their objections. And it is further ordered that the motion is, the order by Judge Fitzpatrick is stayed pending the resolution of the objections filed by the government, which this court will consider on the papers. So that's where we're at. And that's why I titled my video, Huge Win for Comey, an emergency stay for Halligan, and an ugly mess for the DOJ. Now, as I said in the end of that video, and I've kind of said it a few times, maybe there's an explanation for every single thing that Fitzpatrick brought up. There may be an explanation for every single bit. Totally willing to hear that. I still think disclosure is warranted. I still think there's enough here that I think it would serve the ends of justice. I think it would serve the integrity of this case for it all to be disclosed to James Comey, for him and his team to go through it, let them make whatever motions they want based on it, and then let's hash those out. If it was all done correctly, if there's an explanation for all of this, and there was no violation of Comey's rights at any point, there was no misconduct, there wasn't a privilege spill, it's all on the up and up, then it's better for the case it's better for this case as it goes forward for all of that to be worked out, for it to be established that nope, there actually was no violation of Comey's 4th, 5th, or 6th Amendment rights. There is no attorney-client privilege spill. There was no mishandling of the search warrants or illegal searches or inappropriate searches of the materials. Halligan did a fantastic job before the grand jury, knocked it out of the park, like whatever. Like it would be so much better for this case, regardless of what you think about the defendant or the prosecutor or the president. It would be better for the ends of justice, just given the circumstance we find ourselves in with the case and everything we know about it. It would be so much better if it just all got hashed out. Disclose the grand jury proceedings to the defense, let them make their motions to dismiss or motions to suppress or whatever else. The judge can deal with those motions. The parties can go back and forth on it and then make a decision on them. And the case can move forward. I think everybody's reactionary takes on this are all based in Comey's bad. I want to see harm done to him. And that's just it's ends justify the means thinking. And we can't let ourselves get pulled into ends justify the means thinking. So, all right. I'm going to check my time. Okay, I'm going to pause the recording, and I'm going to check the time of how long this episode is and decide whether or not I can get into the next issue I have lined up to go over with you guys. So, be right back. Okay, I looked through some of the topics I have lined up and the materials I've lined up for them, and I know myself well, and I know that I'll go into it thinking it'll be a 20-minute presentation and it'll be an hour and 20 minutes. So I'm going to save those. And last week I released an episode on Sunday night. I released it on Substack first, which was something I'd regularly done. I would release my latest podcast on Substack first, and then like half a day later or a day later, I would put it out everywhere else. So I want to do that again. So next episode, I have some stuff to talk about with terrorism and cartels, perhaps J6 bombing, the J6 pipe bombs. So, and then of course there will be new Comey material by then. I'm sure that case has been hyperactive especially compared to all the other cases I follow. So I'm going to block all that stuff out for a Sunday episode, most likely. And I'll see you guys there. So if you're not already subscribed, justhuman.substack.com. You can go to my link tree and you'll find all the places I'm at. X, and I got my threads linked on there. If you're not on X, you just want to read my threads, you can read them there. But justhuman.substack.com is the best place to follow me. It's also the best way to support. $7 a month buys me a cup of coffee and contributes to my Pacer fund. But I welcome your support, and whatever way you choose to do it, you know. And thank you guys very much. I'm really enjoying the content that we've been looking at and all the stuff we're learning. Hey, Hercules. So Hercules is here. He is, I think he's ready to go out. What do you need? Do you need something? Do you want to make an appearance? Hop up here. Come on. Come here. Make your appearance. Come on. I'll back up. Come on. Right here. Come on. There we go. All right. Ready? Do you have anything to say? You speak? Can you speak? You speak? No. All right, I got you. All right. Thanks, guys. Really appreciate y'all. Have a blessed day. Be righteous to one another. Remember, we're all just human. See you next time. All right, we're going.